Mr. Mellons? Mr. Mellons, if you're driving, you're going to need to stop, or I'm going to stop your video.
All right. Good morning, ladies and gentlemen. We are going, sorry about that. We're going to begin with our misdemeanor all-purpose calendar. This is with the State Court of Fulton County. These are a list of cases in which individuals have been accused of misdemeanor offenses. Before I continue, is courtroom 2 available? Ms. Falk, good morning. Have you seen? Okay, good. Thank you.
Good morning.
Good morning. As I was saying, these are a list of misdemeanor cases in which individuals have been accused of offenses. They've had their initial appearance, bonds have been set, and today we're going to determine the status of the cases, including how the defendants would like to move forward. We would be addressing either plea hearings or arraigning the case and accepting a not guilty plea to further notice the cases for trial, and or to consider bond modifications, probation revocations, as well as to set aside or consider setting aside bench warrants. If you're a defendant on the calendar today, please remember that you have a right to remain silent. Anything you choose to say about your case, your statements can and will be used against you. You have a right to an attorney. If you cannot afford one, one will be appointed to represent you. All right. Courtroom 2, I have Ms. Vigiletti and Mr. Haddad, I think, as well as Mr. McLean. So I have the trio today. All right, good morning, Mr. Haddad. How are we proceeding?
Your Honor, I think we got a probation revocation ready if the court wishes to handle it.
All right. I'm having a problem getting Odyssey to start. So I'm going to, let's go ahead. Miss Allen, she's present. All right, good. Miss Allen, if you don't mind, do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, Your Honor.
All right. Which case number is this, Mr. Haddad?
Your Honor, this is position number 6 and 7, Stanley Matthews.
All right. And Ms. Haddad, if you don't mind reading the style of the cases, both of them, while my Odyssey just keeps revolving around me.
Absolutely.
Apologize. What defendant are we on?
I'm sorry?
Who is this that we're on?
This is Mr. Matthews from the probation revocation calendar.
Thank you.
Please
Oh.
proceed.
Thank you, Judge. On position number 6, Stanley Matthews, that's 20 CR 003376F as in Frank. And position number 7 is Stanley Matthews again, it's 24 PV 000386.
Okay, thank you very much. Mr. Matthews, my name is Judge Lal. You've been advised of your right to remain silent, and your attorney is Mr. Haddad. We are going to address a revocation matter in your particular case. We have Ms. Allen with the probation office who is going to recite the basis of the probation violation and what the state is recommending. Ms. Allen?
Your Honor, the defendant failed to complete 40 hours of community service. He failed to complete anger management classes, as well as pay probation supervision fees of $294. He also failed to pay the court fines of $275. Probation recommends that the defendant be allowed to continue on probation to satisfy the terms of probation.
Give me a moment.
Hey, y'all back here, please be quiet.
Mr. Haddad, this will be noted as a probation violation and he'll be continued on probation. Any questions?
No, Judge, thank you.
All right. Mr. Matthews, I'm going to continue your case on probation. You're required to report to the probation office on Monday before 3 p.m. at 132 Mitchell Street in downtown Atlanta. If you fail to report, probation will simply issue another warrant. To make sure that you do continue with your reporting requirements, and you need to start completing your 40 hours of community service. So you'll be required to complete at least 10 hours a month for every time that you report to probation, and to make sure that you complete the rest of the time. Thank you.
Thank you, Judge. Yes.
Next case, Mr. McLean or Mr. Haddad?
Your Honor, this is position number 5 on the probation violation. Michael Marcus.
All right. You're going to have to read that style of the case again, please.
Absolutely, Judge. Position number 5, Judge Michael Marcus, 23 CR 004148Y. That's a probation violation, Judge.
Okay.
Your Honor, the defendant failed to pay the probation supervision fees. Defendant failed to report to probation on October the 26th, 2023. The defendant failed to report November 2nd, 2023, 11/16/2023, as well as the defendant failed to complete the domestic violence counseling class. It's 131 days remaining on his case. At this time, probation recommends that his balance be revoked.
When was his conviction date?
Your Honor, July 18th, 2023.
Okay, 131 days, and let me see. Ms. Strong, are you able to tell me how many days he's already served?
One moment, Judge.
Date on
Your Honor, he's been in custody since March the 6th.
March the 6th, okay. 15 days, 30 days. He's got 131 days left. Okay, yes, Mr. Marcus, this is a probation revocation case involving 23 CR 0041448Y. And in that matter, you have failed to complete the requirements of your sentence, and the state is seeking to revoke the remainder of time that you left on your probation and have you served out the rest of the time in jail. One of the requirements was completing a domestic violence intervention program, which is a 24-week program. However, the remainder of time that you've left on probation won't allow you to complete that particular program. So I'm considering revoking your sentence and having you serve out the rest of the time in jail, giving you credit for 30 days. Mr. Haddad?
Your Honor, I understand where the court is potentially going with this. I did want to mention that my client is 23 years of age, Judge. He reported to me that he was working a couple of different jobs, including Little Caesars, Judge. He initially reported 2 or 3 times very early on, signed in, but so that the paperwork was not there. That's neither here nor there, because ultimately it is his obligation to follow up and make sure to report, which he obviously failed to do. On his behalf, he wanted to inquire whether his probation can be reinstated. I understand there's not a lot of time left. I'm not sure if the court, if the court is not inclined on reinstating, if the court would be willing to consider essentially revoking him for 60 days instead of the balance, Judge. 60 days and close out the case, Judge.
All right. Let me see. Who's my pretrial? Ms. Tyson, any arrests by Mr. Michaels since his conviction in July of 2023?
And this is
This is on the-
Michael Marcus, right?
Michael Marcus, yes.
No, Your Honor, this was his last arrest.
Okay. I'm going to revoke his probation, give him credit for the 15 days that he has left at the Fulton, that he has left on probation, and I'll give him a 2-for-1 benefit. So it will be minus 40. That's I believe he has 50 more days to serve at the Fulton County Jail.
Thank you, Judge.
No, thank you.
Your Honor, my apologies. I'm writing the notes down. For him, you said revoke his balance. I'm sorry, I didn't hear you.
It is giving him credit for the 15 days, so he would have, so that would be counted as 30 days. And he'll have 101 days left. So he'll have 50 more days to serve at the Fulton County Jail, since the sheriff gives a 2-for-1.
Okay.
All right, Mr. Haddad, who do you have?
Judge, this is position number 13, Perry Hill. That's 24 CR.
Oh, I'm sorry. Is this on the probation revocation calendar?
I apologize, Judge. No, that is on the regular state all purpose.
Oh, I'm good with that then. Thank you. And my Odyssey is now behaving. So I appreciate you chiming in for me. Thank you.
Thank you, Judge. And
This is position 13?
yes, Perry Hill.
Yes, sir.
And Judge,
Yes, sir.
I'm so sorry, Judge. I apologize. This is a global resolution. There's a case number that's on the calendar, but this prosecutor has included another case. It's on the,
I see it. Mhm.
So
I
that
do
is,
see it.
all right, we're ready for a negotiated plea, Judge, on those two cases, Judge.
All right, thank you, sir. This is Mr. Perry Hill, position 13 on the SAP calendar. His accusations are 24 CR 000-896E, in which he's accused of battery, family violence, and there's an additional case, 23 CR 004438E. And I'm not certain of the offenses in that case. Ms. Falk, what were the charges in that case? Oh, who is Mr. Graham? Yes, sir.
Good morning, Your Honor. It is battery family violence.
All right, both of them are battery family violence?
Yes, Your Honor.
All right, and the state has a global offer. Mr. Hill, you've been advised of your right to remain silent. Your attorney is Mr. Haddad. May I place you under oath for purposes of the plea? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Repeat?
Yes, ma'am.
Thank you. All right, Mr. Graham?
Thank you, Your Honor. The state's offer on the first case, 896E, 12 months consecutive to the 438E, balance prorated, FVIP, 40 hours community service, no further contact with Rochelle Marshall. And on the 4438E, 12 months, served 180 days, credit for time served 75 days. That's the period from July 13th, 2023 through August 31st, 2023, and February 24th through today. So the total will be 24 months, served 180 days, credit for time served 75 days, balance probated, FVIP, 40 hours community service, no further contact with Rochelle Marshall.
Mr. Haddad, do you stipulate to the factual basis, venue, and ID for both cases?
We do, Judge.
And does he understand that this will be up to a 2-year probation?
He does, Judge.
And Mr. Hill will be required to serve an additional 15 days at the jail before he starts probation?
I'd explained that to him, Judge.
All right. And that this will be 2 convictions for battery family violence on this record. Any subsequent arrest can result in a felony arrest.
Understood, Judge. I talked to him about that as well.
All right.
And Your Honor, I'm sorry to interrupt. I failed to sound for the victim. If we can sound for Miss Rochelle Marshall.
Rochelle Marshall, if you're present, you're free to start your video and unmute. All right. Okay, just 1 minute. Rita Smith, could you please unmute? Rita Smith.
Yes, ma'am.
Ms. Smith, on your screen, you have pictures of your children, which are very inappropriate for a criminal calendar. You either remove that screen or you can come back on Zoom once you've done so. But I'm going to have to remove you from Zoom. All right?
Okay.
Will the host please remove Rita Smith from Zoom? Thank you. All right. Mr. Hill, have you consumed any medicine or alcohol?
Ma'am.
And have you understood your cases and the offer that's being made to you?
Yes, ma'am.
Are you satisfied with the legal services you've received?
Yes, ma'am.
And is anybody forcing you or inducing you to take this plea today?
No, ma'am.
Has it been explained to you that this will be 2 convictions for battery family violence on your record? And if you're arrested for a same or similar offense in the future, it will automatically be a felony charge.
Yes, ma'am.
Are you still willing to move forward with this plea offer freely, willingly, and knowingly?
Yes, ma'am.
If you decide to move forward with this plea offer, you would have to give up your constitutional right to a trial before a judge or a jury. You will not have the opportunity to have the assistance of counsel to come back to court, confront your accuser, challenge the evidence brought before you, be able to present any defenses or arguments on your behalf, as well as have the state carry its burden to prove the charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
In case ending in 23 CR 4438E, how do you plead?
Yes,
Your sentence is 12 months to serve 180 days, credit for time served 17 days. You have additional 15 days to complete at the jail. And you'll be required to do a domestic violence intervention program, 40 hours of community service, and have no contact with Rochelle Marshall. In case ending with 24 CR 000896E for battery family violence from February 22nd, 2024. How do you plead?
yes,
This will be 12 months probation consecutive to the earlier case. In other words, this will be an additional 12 months tacked on. So your probation will be up to 24 months less the time you've served at the jail. It will have the same requirements of the domestic violence program and 40 hours of community service. And whatever, if you've done the community service and the domestic violence for the first case, that would be applied to your second term of probation. You won't have to do it again. However, you will still be required to stay 200 yards away from Rochelle Marshall and not have any contact with her for up to the next 2 years. Understood?
yes, ma'am.
Your community service may be done at any nonprofit agency that's not a church and not a school. As soon as you've completed your 15 additional days at the jail, you must immediately report to probation at 132 Mitchell Street in downtown Atlanta. You must complete your domestic violence program within the first 12 months of your probation. Understood?
Yes, ma'am.
Thank you.
Judge, I may have misheard, but on 23 CR 004438E, I thought the court stated that he gets credit for 17 days. I just want to make sure it is actually 75 days.
Oh, did I say 17? I might be my weird accent. It's 180 days credit for time served, 75 days.
Great, thank you, Judge.
Okay.
That's it. Your Honor, we're ready for position number 9 on the state all-purpose, John Davis.
Yes, sir. Miss Rockman, who's your client?
Good morning, Your Honor. My client is Stephen Albert. He is position number 1 on the state all-purpose.
All right. I'll see if the jail has him in the courtroom, or maybe he still needs to be brought over. All right.
Thank you.
We have John Davis, case number 24 CR 1216C. Mr. Davis is accused of criminal trespass from January 17th of this year. Mr. Davis, you've been advised of your right to remain silent, and your attorney is Mr. Haddad. Where's my cheat sheet? Oh, okay, here we go. All right. Mr. Haddad, with regards to this case, this is going to be a negotiated plea. And Mr. Davis, may I please place you under oath? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Thank you. Mr. Grant?
These are 2 cases, Judge.
Yes, sir. I have that too. Oh, I do beg your pardon. Yes, he has another case, 24 CR 1195C. And that's also for criminal trespass, I believe. All right. Yes. Mr. Grant?
Thank you, Your Honor. And just to note, the 1195C case is on the SAP calendar for March 28th.
Oh, we'll just take it off the calendar.
All right.
Thank you.
So the state's recommendation in the case ending 1216C, 12 months, served 54 days, credit for time served 27 days. That includes a period from January 17th through 19th of 2024 and February 27th through today. Balance suspended. Stay away from the Truist Bank at 303 Peachtree Center Avenue, Atlanta. And the case ending 1195C, 12 months, served 48 days, credit for time served 24 days. That includes the period from February 27, 2024 until today. Balance probated. Stay away from the Truist Bank, 303 Peachtree Center Avenue, Atlanta.
All right. Mr. Haddad, does your client stipulate to the factual basis, venue, and ID?
Yes, Judge.
Mr. Davis, have you consumed any medicine or alcohol recently?
No, ma'am.
Have you understood the proceedings so far?
Yes.
And are you satisfied with your legal services?
Yes.
Repeat.
Yes.
Is anyone forcing you or inducing you to take this plea offer today?
No.
And you understand that even though the balance will be suspended, you'll still be required to stay away from the Truist Bank at 303 Peachtree Center in downtown Atlanta?
Yes.
And if you return to that location, you'll be arrested again? You understand that?
Yes.
Do you also understand that if you decide to plead guilty to these two cases, that you would have to give up your constitutional right to a trial? You will not be able to challenge these charges in a court of law before a judge or a jury. You will not have the assistance of counsel, not to be able to confront your accuser, and as well as have the state carry its burden to prove the charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes.
How do you plead to the 2 counts of criminal trespass in these 2 cases?
Guilty.
Your sentence is 12 months to serve 48 days, credit for time served 24 days for the case from 24 CR 1195C, and for the later case 24 CR 1216C, your sentence is 12 months to serve 54 days, credit for time served 27 days. Balance suspended in both matters. You are to stay away from the Truist Bank at the Peachtree Center Avenue location. That concludes your case. And the case ending in 1195C is going to be removed from the March 28th calendar.
Thank you, Judge.
Thank you.
Your Honor, this is position number 2, Beavers. You can have this. That's ready for a plea, Judge.
Merrill Beavers is accused of criminal trespass from March 7, 2024 at the Taverna restaurant. Case number 24 CR 001-081Y. Mr. Beavers, you've been advised of your right to remain silent, and your attorney is Mr. Haddad. May I place you under oath for purposes of the plea?
No.
Mr. Beavers, please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Thank you. Mr. Graham?
Thank you, Your Honor. The state's recommendation in this case is 12 months to serve 30 days. Credit for time served 15 days. That includes the period from March 7th, 2024 until today. Balance suspended, stay away from Taverna restaurant.
And does he have any probation holds at the present time?
Your Honor, I believe he's currently on probation.
Okay.
from-
I just want to make sure he doesn't have a hold.
Okay.
Okay. Mr. Haddad, does the defense stipulate to the factual basis, venue, and ID?
Yes, Judge.
All right. Mr. Beavers, have you consumed any medicine or alcohol recently?
No, ma'am.
And have you understood the proceedings so far?
Yes, ma'am.
And do you remember where the Taverna restaurant is?
Yes, ma'am.
All right. You'll be required to stay away from that location. Would that be a problem?
No, ma'am.
If you decide to accept this plea, you would have to give up your constitutional right to a trial. You will not be able to confront your accuser, challenge the evidence brought before you, and have the state carry its burden to prove the charge against you beyond a reasonable doubt. Are you prepared to give up these rights? Are you prepared to give up these rights?
Excuse me, ma'am.
Your Honor, I believe he said yes, ma'am, but
Oh, I
I'm-
couldn't hear him. So I've asked him whether he's prepared to give up his constitutional rights to a trial.
Yes, ma'am.
Again, I cannot hear you. Speak a little louder, even through
I
the
need a
mix.
translator. I said, yes, ma'am. Can I get a translator in Buddhism or something for my trail?
I beg your pardon?
My trail? Saying the master teacher, where's age? My trail.
I'm
Oh.
sorry, Mr. Haddad, what is he asking for?
I'm not really sure, Judge. She's asking you whether you want to plead guilty.
Yes, ma'am, I said yes, ma'am. Do I need to translate in Buddhism or something?
All right, then I'm going to take his case at the end. I don't need that kind of
No,
attitude.
I'm sorry, ma'am.
No, I don't need that kind of attitude. Go sit down. Go sit down at the back.
Judge, can we try to go forward with him for security purposes, please? 'Cause I'm about to take him out.
Thank you, ma'am. Thanks, sir.
Put your mask on.
Sentence is 12 months to serve 30 days. Credit for time served 15 days, balance suspended. He's to stay away from the Taverna restaurant. He's also to report to probation. Today is Thursday, so he'll report to probation on Monday and before 3 p.m. That's for his other case that he's on probation for. I don't know that case number, but Miss Allen or Miss Thomas, do you have this gentleman on probation?
Your Honor, what's his last name? I'm sorry.
His first name is Merrill, like the shoes, and Beavers, Beavers.
Your Honor, the officer submitted a warrant for my approval. I haven't approved it yet, and it would be submitted to the judge for signature.
All right. So, Mr. Beavers, you are now advised that there's currently a request for a probation warrant against you. I would highly recommend that you report to probation this Monday. He's going to be required to report to probation this Monday. And if the warrant is not signed, then he'll be required to complete his 6-week anger management and his MHET. The MHET must be completed within 30 days of Monday. And whatever classes that he is still left over on his anger management, he's just to begin enroll in those classes within 30 days of Monday. Unless the probation warrant's of course signed. Then he'll have to surrender himself back to jail.
Well, location I'll be required to report to, ma'am.
132 Mitchell Street.
132 Mitchell Street
Thank you, Judge.
on Monday before 3 p.m. Thank you.
Thank you. Thank you, Your Honor, Ms. Judge Law. Thank you, Your Honor.
Okay.
Next case, please.
Next, Mr. Smith.
All right. We have Mr. Smith at the jail court iPhone. May I have his position number or full name? Is it
20.
Demetrius?
Demetrius Smith.
All right, got it. Thank you. Position 26. Thank you, Deputy.
You're welcome.
Would that be Mr. McLean's, Ms. Micheletti's? Okay.
Yes, good morning, Judge.
Good morning, Ms. Micheletti.
Mr. Smith would like to enter a not guilty plea this morning.
Yes. This is 24 CR 1079A, in which Demetrius Smith is accused of battery, family violence, and 2 counts of cruelty in the 3rd degree. 3 counts of cruelty in the 3rd degree. Mr. Smith, you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and representing you is Ms. Vigiletti in courtroom 2. Can you see your attorney?
Yes, ma'am.
All right, thank you. Ms. Vigiletti, do you waive a reading of the accusation?
We do.
Thank you. Mr. Smith, you have been accused by the prosecution, which is the Solicitor General's Office of Fulton County, of 1 misdemeanor offense of battery, family violence, and 3 counts of cruelty in the 3rd degree. Upon your entry of a not guilty plea, the case will be further noticed for trial. At the time of the trial, the prosecution has the complete burden to prove the charges against you beyond a reasonable doubt. If the prosecution does prevail and overcomes your legal presumption of innocence, you could be convicted of 1 or more of these offenses and face a penalty of up to a year in prison and or up to $1,000 fine for each convicted offense. The sentences could be served concurrently, that is together, or consecutively, that is separately. Given this information, how do you plead? Mr. Smith, given this information, how do you plead?
Not guilty.
Your case has been arraigned and is going to be further noticed for trial. Anything else, Ms. Vigiletti?
No, Judge.
All right, thank you, Mr. Smith. You'll get notice for your trial date.
Is it any way possible that, he can speak?
You have a right to remain silent, Mr. Smith. Did you have a request of your attorney?
Yeah. I'll call it up.
Okay, thank you.
Sure, we can talk after, okay?
All right, we have a gentleman at Fulton ACDC, or are we addressing someone on I? Okay. Who do we have? Oh, Deputy Milton, is she there?
Yes, Judge, this is Jairo Vasquez Lara. This is the client for which I did request an interpreter.
All right, we have a Spanish interpreter, I believe, who's chimed in. I thought I saw a chat just now. Do we have a Spanish interpreter on Zoom?
She'll be on shortly, about
Okay.
10 o'clock.
All right, so we'll just wait till then. All right. Okay, next case in courtroom 2.
28. Tony. Position 28 on the SAP calendar.
Okay. I have Eugene Demetrius Tony, that's Toney, in case 24 CR 644E. Mr. Tony has been accused of simple battery, family violence. Mr. Tony, you've been advised of your right to remain silent, and your attorney is Ms. Vigiletti. And Ms. Vigiletti, I understand this is maybe moving forward with a plea or an arraignment. How will we?
Yes, Judge, Mr. Tony would like to discuss the possibility of a non-negotiated plea this morning.
All right. So, Mr. Tony, may I place you under oath in the event that you decide to move forward? The other right hand, please. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge? Thank you. Sir, what we're going to do is listen to the prosecution as to what he or she is recommending, and then I will listen to your attorney. And based on the circumstances and your criminal history record, I will let you know which option I'm going to go with, and then you can decide whether you want to plead guilty or not guilty. All right, Ms. Falk?
Yes, Your Honor. Before we get started, I do have an inquiry in regards to the outstanding matter, the foreign hold from Cobb County. Does, by any chance, pretrial know what that foreign hold is for?
Give me 1 second. Let me see if I can find something on it.
Okay, I appreciate it. In the meantime, I can go over the facts of the case and the state's recommendation.
Okay.
So, Your Honor, this incident happened on, let me just pull this up.
February 5th, 2024?
That is correct. At 490 Glen Street Southwest, officers responded to initially to a dispute with weapons. They spoke to Miss Johnson, who stated her son punched her in the face 2 times. She stated her son was wearing a black jacket, black ripped jeans, and fluffy silver shoes. She said the incident happened between 2:30 and 2:40, and her son then fled the location. On scene, there was a security guard at the apartment whose name is Reginald Middlebrooks. He did confirm that Eugene Tony punched his mother in the face twice with a closed fist. When Eugene Tony was questioned, he stated that he and his mother got into a dispute over his cell phone. Miss Johnson did state that her son had assaulted another female earlier that day at 779 Magnolia Street, and there was available camera footage of this incident. As far as the defendant's criminal history is concerned, he has a substantial criminal history, Your Honor, and I would like to point out in particular that the defendant has, at this point, 54 cycles. He has a battery where he pled guilty in Cobb County State Court in 2009. And for that, he received 45 days. He has some theft by shoplifting. He has a simple battery from 2010 where he received 3 months of 3 months jail, 9 months probation. He has a simple battery where he received 8 days confinement, 12 months probation. That was in 2010. Going down, he has, and so far I'm seeing a lot of theft charges, but there was an aggravated assault charge in 2012 in Fulton County where he received 5 years probation. Let's see. He also had some theft by deception charges. He was convicted in 2014 for battery in a public transit vehicle or station where he received 12 months, served 90 days. And we are just at cycle 32 at this point. And he also has several probation violations as well. His most recent conviction looks like a financial transaction card fraud where he received, it looks like 3 years with 8 months confinement, and a willful obstruction of law enforcement officer felony in 2018, where he received 5 years, 12 months confinement. And again, subsequent to that, we have simple batteries, simple assault in 2018, where he received 45 days. And I believe another financial transaction card fraud in 2020, where he received 3 years probation and some more probation violations subsequent to that. Finally, he had a 2023 criminal trespass where he got 60 days in jail. And so that is, again, those are the highlights of his 54 cycles. And as you heard, I mainly focused only on his felonies as well as his violent offenses. For that reason, we believe the state's recommendation of 12 months serve 100 days is more than reasonable. Credit for time served 24 days. Sorry.
I think it was 120, wasn't
it? I apologize. I had pulled up the wrong I pulled up the add-on calendar while I was speaking. 12 months served, 120 days, credit for time served, 46 days, balance probated. We're also asking for MHET, 40 hours of community service, no contact with Gina Johnson, family violence intervention program, stay away from 490 Glen Street Southwest and 779 Magnolia Street, and no firearms. And given those circumstances, we believe this recommendation is more than reasonable.
And the warrant was for a probation violation.
Okay. And thank you so much. And we would like to sound for Miss Gina Johnson in case she is present here today, Your Honor.
Ms. Johnson? Gina Johnson? No, she's not. Okay. Yes, Ms. Vigiletti, what's the alternative that you are seeking?
Mr. Bartles did speak with Mr. Tony's mother, and I did speak with Mr. Tony's father, and both of Mr. Tony's parents are happy that the MHET is a part of this deal. They believe that MH is the source of a lot of these issues that we're seeing with Mr. Tony. And we're just requesting this morning for the court to consider time served on the jail time without amending any of the probation. Mr. Tony does have a hold in Cobb County, and so he will be incarcerated for a while, sorting out the probation violation. We've also worked together to identify a safe place that he can stay that doesn't involve going back to his mom's house with his Aunt Stephanie. And he understands the terms of his probation. He has been here for 46 days. And as I said, has another place to go when he is out of here. He's going to be incarcerated again. So that's our only request this morning, to consider time served on the jail time.
Who is this Aunt Stephanie? I haven't seen that person identified in any of his pleadings.
Yes, this is a new relative I just learned about this morning. This is Mr. Tony's intention for where he will live. I do have her address. But I have not spoken with her.
Okay. I'm just looking at just his history in Fulton County and also reviewing the notes from his jail incident on February 23rd of this year. I think Mr. Tony clearly manifests some violent propensities. I just cannot justify him reducing his time. it will have to be the state's recommendation. Mr. Tony, I'm going to accept the state's recommendation that it will be 12 months to serve 120 days, credit for time served 46 days, which means that you'll have less than 20 days more at the Fulton County Jail. After which then Cobb County has the right to come and pick you up, or during that time to come pick you up to address your probation violation matter in Cobb County. After you've resolved that matter, then you must report to Fulton County Probation in order to complete your conditions. So, Ms. Vigilante, would your client like to move forward with the plea or enter a not guilty?
If I could just have one brief moment.
Certainly.
Could you mute us just for a second?
I guess that was a not guilty.
Okay, Judge, Mr. Tony would like to move forward with the plea as negotiated.
You mean as the state has recommended?
Yes, yes.
All right. And do you stipulate to the factual basis, venue, and ID for the simple battery charge from February 5th, 2024?
We do for the purposes of the plea.
All right. Mr. Tony, do you have you consumed any medicine or alcohol recently?
No, ma'am.
And have you understood the proceedings so far?
Yes, ma'am.
You understand that after your sentence, you'll still be serving additional time at the jail, and then you'll have to report, then you'll be transported to Cobb County
Yes,
to
ma'am.
address your other matter there.
Yes, ma'am.
After you're released from Cobb County, you must report to probation. Do you understand?
Yes, ma'am.
Is anyone forcing you to plead guilty today?
No, no, ma'am.
And are you entering this plea freely, willingly, and knowingly?
Yes, yes, ma'am.
If you decide to plead guilty, you would have to give up your constitutional right to a trial in
Yes,
front of a
ma'am.
judge or a jury.
Yes, ma'am.
You will not have the assistance of counsel to go back to court, to confront your accuser, challenge the evidence brought before you, present any defenses or arguments that you would wish to present, and have the state carry its burden to prove the charge against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
How do you plead to one count of simple battery, family violence?
Yes, sir.
Your sentence is going to be 12 months to serve 120 days, credit for time served 46 days. You have additional time to serve at the Fulton County Jail. After you've completed your time at the Fulton County Jail and resolved your probation violation in Cobb County, you must report to Fulton County Probation at 132 Mitchell Street in downtown Atlanta. Mr. Tony, your Fulton County history has a list of probation violations. And if you do not comply with this probation and a probation warrant is issued, please understand that I'm most likely not going to allow you to remain on probation, but instead send you back to jail. Do you understand?
Yeah.
Good. When you report to probation, you'll be required to complete an MH evaluation. That evaluation must take place within 30 days of reporting to the Fulton County probation office. You'll be required to complete 40 hours of voluntary community service, and you must begin with 5 hours per month every time that you report to probation. You shall have no contact with Gina Johnson. You have to stay 200 yards away from Ms. Johnson and not communicate with her in any way, form, or manner. You're also to stay 200 yards away from 490 Glen Street in Southwest Atlanta and 779 Magnolia Street in Atlanta, Georgia. At all times, you're not allowed to own or possess any firearms. You must report to probation every month. Failure to do so will result in a revocation. Thank you.
Thank you, Judge.
Position number 25 and 24.
I'm sorry, we're not ready. I'm sorry, no.
What about Sean, please?
Yeah.
Keep going. We can go to position number. We can actually go to jail court's iPhone.
All right.
Okay. We have position number 1. He has a private attorney. I
Thank you,
believe
sir. She is. Thank you. This is State versus Stephen Albert. Ms. Rothman, have you had the opportunity to speak with Mr. Albert, or are we ready to move forward?
We're ready to move forward, Your Honor. We did file an entry of appearance yesterday, a not guilty plea, and a waiver of arraignment on this case.
All right, thank you. Mr. Albert, your case number is 23 CR 7503E. You have 10 separate misdemeanor offenses, including including 5 separate counts for DUI, speeding, improper erratic lane change, failure to use a turn signal, possession of an open alcohol container, and failure to maintain lane, stemming from an October 22nd, 2022 incident. Your attorney has entered a not guilty plea on your behalf, and your case will be further noticed for trial. Thank you. That concludes the case.
Thank you, Your Honor.
Mhm. Jail court iPhone, we have concluded with Mr. Albert's case.
What was that?
We've concluded with Mr. Albert's case.
Okay,
It's further notice for trial.
okay.
Thank you. All right, still waiting on our interpreter. So courtroom 2, are we ready with our next case?
We're gonna go with position number 20 on the SAP tablet.
Good morning, Your Honor.
Murray.
Good morning, Mr. McLean.
Mr. Murray Brantley with a hyphen in between is a guilty plea. I had put that down as a TBA to be announced because of interviewing
All right,
format, but it turns out that he is okay with the state's recommendation.
sounds good. 24 CR 001-090Y. This is State versus Jasper Murray Brantley, accused of loitering and prowling, willful obstruction of a law enforcement officer, misdemeanor possession of marijuana, pedestrian darting out in traffic, and reckless conduct. These are the charges stemming from a March 7th, 2024 incident. Mr. Murray Brantley, you've been advised of your right to remain silent, and your attorney is Mr. McLean. May I place you under oath for purposes of the plea? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge? Thank you. Ms. Falk?
Yes, Your Honor. The state's recommendation is 12 months probation, served 28 days, credit for time served 14 days. That's going to be from March 7th to March 21st of 2024. Balance suspended. Stay away from 2455 Piedmont Avenue, which is Taqueria Fiesta. Count 2 is 12 months probation concurrent with count 1. Count 3 is a null pros. Count 4 is 12 months probation concurrent with count 1. Count 5 will merge with count 2, the willful obstruction of law enforcement officers. The state would ask the defense to stipulate to venue, factual basis, and identification for the purposes of this plea. That's all for the state.
For those purposes, we do so stipulate. As a point of clarification, considering that there are very few conditions of probation, could we?
There's no probation.
Right, I stated balance suspended.
Right, very good.
All right. Do you stipulate? I'm sorry, he did stipulate. All right. Mr. Murray Bradley, have you consumed any alcohol or medicine recently?
No, ma'am.
And have you understood the proceedings so far?
Yes, ma'am.
Are you satisfied with your attorney? I'm sorry, repeat again?
Yes, ma'am.
All right. Ladies and gentlemen, the reason I need to hear your response is because, first of all, this is a virtual proceeding. And second of all, a plea hearing is a constitutional process. So I need to make sure I ask the appropriate questions to understand that you are entering a plea freely, willingly, voluntarily, and knowingly. So it's very important that I hear your response because we are recording this proceeding and it will be made part of the record. This is a requirement by law. So if I keep asking you to repeat, it's not because I'm hard of hearing. At times I am, especially when my husband's concerned. But I need to hear you in order to put you on record. Okay?
Yes, ma'am.
Thank you.
Yes, ma'am.
Mr. Murray Brantley, have you, excuse me, if you decide to enter this guilty plea, you would have to give up your constitutional rights to a jury trial or a bench trial. You will not have the assistance of counsel. You will not be able to come back to court and face your accuser, challenge the evidence brought against you, have the state try to prove the charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
And how do you plead to one count of loitering and prowling, willful obstruction of a law enforcement officer, and pedestrian darting out in traffic?
Guilty, ma'am.
All right. Your sentence is going to be 12 months to serve 28 days, credit for time served 14 days. The balance is suspended. However, you cannot return to the Taqueria Fiesta restaurant. If you return to that location at 2455 Piedmont Road, you will be arrested again. This will be a guilty plea to 3 charges. Count 3, the misdemeanor possession for marijuana is null pros, and count 5 for reckless conduct will merge with the willful obstruction charge. Thank you. Next case, please. Deputy Milton, ACDC, we're still waiting on the Spanish interpreter. As soon as he or she arrives, we'll be able to move forward. All right, Miss. Yes.
Position number 17 on the SAP calendar, Lincoln Alon.
That's just Alan.
Huh?
It's just Alan. His first name's just Alan.
This is State versus Alan J. Lincoln, 24 CR 1100B, accused of simple assault and terroristic threats and acts from October 22nd, 2023. Mr. Lincoln, you've been advised of your right to remain silent, and your attorney is Mr. McLean. Mr. McLean, this is position 17, and this is going to be a negotiated plea.
Correct.
Okay. Mr. Lincoln, please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, Your Honor.
Thank you. Mr. Grant?
Thank you,
It's
Your Honor.
Mike.
Oh, sorry. Ms. Paul?
I may have actually stolen Mr. Graham's case. My apologies. The state's recommendation is count 1, 12 months served, 30 days, credit for time served, 15 days. That's from March 7th to March 21st. Balance probated, 40 hours of community service. No further contact with Kara Morse. Stay away from North Fulton Hospital unless receiving medical treatment, and 8 weeks of anger management. Count 2 will merge with count 1. The state would sound for Miss Kara Morse, and we would ask the defense to stipulate to venue, factual basis, and identification for the purposes of this plea. That's all for the state.
Your Honor, we do so stipulate for these purposes.
All right. Thank you. Kara Morse? Or Kara Morse? Mr. Lincoln, have you consumed any medicine or alcohol recently?
No, Your Honor.
And have you understood the proceedings so far?
Yes, Your Honor.
Are you satisfied with the legal services you've received?
Yes, Your Honor.
And is anyone forcing you to take this plea today?
No, Your Honor.
If you decide to plead guilty, you would have to give up your right to a trial in a court of law before a judge or a jury. You will not be able to confront your accuser, challenge the evidence and witnesses brought before you, present any defenses or arguments you may have, and have the state prove the charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, Your Honor.
How do you plead to one count of simple assault?
Guilty.
Your sentence is going to be 12 months to serve 30 days, credit for time served 15 days. If you have no other holds at the Fulton County Jail, you shall report to probation next Monday before 3 p.m. at 132 Mitchell Street in downtown Atlanta. While you're on probation, you will complete 40 hours of voluntary community service. You must begin completing at least 5 hours per month and finish the rest of the community service, completing 5 hours every month when you report to probation. You may do the community service at any nonprofit agency that's not a church and not a school. You're to have no contact with Cara Morse, and I assume that's the individual at the North Fulton Hospital. You are also to stay away from the North Fulton Hospital unless you have a specific appointment with a healthcare provider or you are seeking emergency medical treatment. Understood?
I understand, Your Honor.
All right. That concludes the case. Count 2, terroristic threats and acts will merge into count 1. Thank you.
Thank you, Your Honor.
Next, we could go to SAP, position number 18.
This is Ogarius McGee, accused of simple battery family violence from February 26, 2024, case number 24CR1008A. Mr. McGee, you've been advised of your right to remain silent. Your attorney is going to be Ms. Maureen McLeod. Ms. McLeod, how are we proceeding with your client's case?
Your Honor, my client has 2 outstanding cases in Fulton County before Judge Porter. I was before Judge Porter yesterday, and the prosecutor and I agreed that based on an evaluation that was done in another matter, not in Fulton County, in the federal system, that we agreed to order another evaluation for him. It has been signed by the judge. We are asking for signature bond for him because we believe that ultimately all of his cases are going to be dismissed.
All right.
So this was a joint request for the mental health evaluation for him.
Right.
So we're asking for a signature bond for him, Your Honor.
Right. Oh, I'm sorry, that's news to me. So did Judge Porter by any chance arraign the case as well?
This new case? No, Your Honor, this was not done.
All right. Ms. Falk, any comment or any insight with regard to this proceeding?
I am kind of a little confused at why this bond request wasn't made before the judge who heard all of the cases. But I can respond to that. The defendant has currently 3 open cases in our jurisdiction. One is he received a simple battery in February of 2023, and that case was 23CR004765B. He has a 23CR004766B case. That's terroristic threats and acts, as well as simple assault family violence. And then this case, the simple battery family violence, 24CR001008A. Sorry.
Ms. Falk, is it possible for us to talk about this in a breakout room? Because there are some things that I really need to share with you.
Okay. All right. I think this needs a breakout. Presently, I'm not inclined to grant the bond request. All the 2 other cases ending in 4765B and 766B are both set before Judge Porter on April 25th before Her Honor. And he's already got a court date. I'll be glad to put this new case, 24CR1008A, also before Judge Porter. I just need to, Ms. McLeod, after your discussion with Ms. Falk, you can, I'll arraign the case and reset it with the April 25th matter as well, unless I have further information about this bond modification request. All right?
Thank you, Your Honor.
All right. So, Ms. Falk, I don't know when she's going to have a moment to talk to you. Mr. McGee, presently, this particular case is pending arraignment and is also going to be reset on April 25th with Judge Porter, unless I hear from your attorney later on. So we're going to have to leave him in the courtroom too and take the next case until Ms. McLeod and Ms. Falk have had an opportunity to speak.
We can go to position number 1 on the add-on calendar. I said Mario.
All right. This is State versus Mario Dawson, position number 1 on our add-on calendar. Mr. Dawson's accused of simple battery from February 26, 2024, accusation 24 CR 916D. Mr. Dawson, with regards to the add-on, you have been advised of your right to remain silent, and your attorney is Mr. McLean. And this is it still a non-negotiated plea, Mr. McLean?
Yes, Your Honor.
All right. Mr. Dawson, if you please raise your right hand. Do you solemnly swear the testimony you provide will be the truth to the best of your knowledge?
Yes.
All right. We are first going to hear from the prosecutor as to what the recommendation is, and then I'll hear from your attorney. I will let you know which option I will select before you decide whether you want to plead guilty or not guilty. Ms. Falk?
Yes, Your Honor. This defendant, just to give you a background on his history, has 20 cycles. Going to kind of the most recent cases, he has a disorderly conduct, terroristic threats, and simple assault. That case was null prost on November 22nd, 2022. He does have a previous aggravated assault conviction, and that is going to be 17 SC 151792. That is out of Fulton County. And he's had probation violations on that case subsequent to his conviction. He also had a 14 SC 131382 conviction in 2016 for aggravated battery. He received 6 years probation on that case. And his he has a variety of shopliftings as well. His most recent cases are arrests in 2022 for disorderly conduct, where he received 12 months, served 28 days, an arrest in August of 2023 for a fray, and then this case. In this particular case, Your Honor, this incident happened back on February 26th. Officers responded to 535 Lee Street Southwest, which is Texaco. They met with Mr. Ibrahim Lee, who stated that the defendant walked up to him unprovoked and started punching him in the face repeatedly. Officers did speak with a Texaco employee and an independent witness who did not wish to be identified, who did confirm that Mr. Dawson began striking Mr. Lee with his fists. There was video footage that was captured by the video cameras at the Texaco gas station where the incident occurred, and the defendant was taken under arrest. The state's concern here is that there is a history of violence with this defendant, and this incident appears to have been unprovoked, according to both Mr. Lee and the witnesses. For that reason, the state's recommendation is 12 months, serve 120 days, credit for time served 24 days. The recommendation would be for him to serve from February 27, 2024 until today's date. Balance probated, 40 hours of community service, 8 weeks of anger management, no further contact with Ibrahim Lee, stay away from 535 Lee Street Southwest in Atlanta, Georgia. which is the Texaco gas station. Our office did have an opportunity to speak with Mr. Lee, and he did state that he agrees with the plea offer and he will not be on Zoom. However, we would like to sound for him just to confirm that he is in fact not planning on attending today. And that's all for the state.
Ibrahim Lee? All right. And Ms. Fall, just to clarify, I don't know whether you misspoke. You got the written recommendation as 100 days on the calendar. Was that a typo? But you said
Correct.
120.
Pardon?
You said 120. Was it 100 or 120?
Oh, it's 100 days. I apologize if I misspoke.
Okay.
Credit for time served 24 days.
Oh, yeah. Okay. All right. Mr. McLean, what does your client seek?
Your Honor, the state's recommendation would involve an extra 26 days in jail, and that is the single item to which he would address the court's attention and ask the court to give him a break on that. We understand what his record is. We would point out that respectfully, the state does have a witness, but if they're not willing to come forward or give their name, really the video becomes the witness. I have not seen the video. This case is such that Mr. Dawson is willing to make efforts on probation. He realizes he has not always been successful on probation, but nonetheless, he's willing to make the efforts on probation. And so if the court were to see its way clear to giving him something very close to time served or time served itself, no more than say 3 or 4 extra days in jail to right. And I'm making clear to Mr. Dawson, he is asking for time served, but if the court were to be able to give him time served on the unnegotiated plea, he would very much appreciate that. I had received an email from a colleague who said, basically, send this back to my courtroom and let me have the case if it's not time served. So that's the kind of direction I'm headed in.
Mr. McLean, honestly, based on how you've described the case, I think he should go to trial.
No, I'm good. I'm good. I'm gonna take my
But otherwise, I'm going with the state's recommendation. It's really up to him. But he'll need to serve additional time at the jail.
Let's mute and let's just.
Okay. Shall we proceed, Mr. McLean? Mr. McLean, please unmute. We are.
Let's unmute. Against the advice of counsel, he is going forward as planned. He is asking the court to accept his plea.
And based on the state's recommendation, which is 100 days, credit for time served 24 days.
Right. I've told him I expect he would be released 26 days from today to go on to the park.
All right. Mr. Dawson, and Mr. McLean, like you said, against the advice of counsel, but ultimately it is the defendant's decision after he's consulted with counsel. Mr. Dawson, have you consumed any medication or alcohol recently?
No,
And have you understood what's going on in this case?
yes,
And have you understood the explanations provided by your attorney, Mr. McLean, as
Yes.
to your options?
yes,
And your decision to move forward with this plea, is that decision being made freely, willingly, and voluntarily?
yes. Your Honor, can I ask you, once you're done, can you explain it to me when I will be released after once you're done? I'm moving freely, yes.
All right, based on the calculation, you've served 24 days at the Fulton County Jail. So that means it's 100 days.
April 17th, Your Honor, is the calculation.
All right, April 17th, you have less than 30 more days to serve at the jail.
All right, sure.
But you understand that after you've completed your jail time, you'll be on probation, where you have to complete certain conditions. And if you violate those conditions, you'll be back in jail to serve out the rest of the year.
All right.
I do have his contact information to send to probation, and he does know where to report on probation. You do know.
Probation, where
You remember what we
probation?
discussed?
No,
Okay.
it was
Could we mute again for a moment, Your Honor?
In fact, yes, we're going to take the next case and then we can come back to him. Next case, please.
We have positions 4 and 5, Mr. Brewster.
Your Honor, I needed to speak to Brewster.
Okay,
Breakout room. I was not able to see him yesterday. He never came out to the booth, so.
all right. Do you have your laptop?
I do, Judge.
All
I
right,
do.
as soon as you come on the video, the host, Ms. Strong, will place Mr. Haddad and jail court iPhone. There he is. All right. Ms. Strong, if you could place Mr. Haddad and jail court iPhone in a breakout, please.
Okay.
Thank you. All right. In the meantime, Ms. Vigiletti, your next case. Courtroom 2 can unmute. Mr. Haddad, I think you'll be getting a message on your screen. Okay, good.
Judge, next to me is positions 24 and 25, Mr. Kenneth Scott.
Okay. Is any ETA on our Spanish interpreter? Ms. Strong?
No, ma'am, nothing yet, but she did reply to the email stating of the with the request. So I guess
Okay,
she'll be on shortly.
All right, she's probably in another proceeding and she'll get you as soon as she can.
Okay.
Deputy Milton, did you have a question?
Yes, I'll be right back. I'm gonna go get those 3 females. And I'll be back, so I have to take Mr. Vasquez with me.
All right, thank you. And Ms. Falk and Ms. McLeod, did you have an announcement from your discussion?
We haven't spoken yet, Your Honor.
Yes, Your Honor, we hadn't been placed in the breakout yet.
Okay.
I apologize.
Well, no. It is definitely not your fault. I have been doing the pleas up until just now.
Okay,
Okay.
so Ms. Falk and Ms. McLeod?
Yes, please.
Okay, give me a moment.
But not yet. Let me address
Okay.
position 24 and 25. Is that Mr. Graham's case or Ms. Falk?
No, it's going to be mine, Your Honor.
Okay. Kenneth Scott is position 24 and 25. He's got 23 CR 576Y, accused of theft by shoplifting and willful obstruction of an officer from September 24th, 2023. He has a bench warrant stemming from that case, 24 FTA 264 from December 6, 2023. Mr. Scott, you've been advised of your right to remain silent, and your attorney is Ms. Vigiletti. With regards to both your cases, we are going to move forward with Ms. Vigiletti.
Yes, Ms. Fox, I just sent you a counter offer via email. If you're agreeable, we can move forward with a plea. Otherwise, we can discuss the possibility of a non-negotiated plea this morning.
I did see it. However, that is a statutory fine.
I see, okay. And the other portion, the ADET?
The state is willing to remove the ADET.
Okay. Okay, Judge, what we're discussing, as I told Ms. Fox this morning, there is a $300 fine associated with willful obstruction of law enforcement. And as a result of his arrest, Mr. Scott did lose his job and was wondering if it's possible to convert that fine to community service this morning.
He has 12 months to pay that off.
Yes.
So no, he'll pay the fine.
Okay.
This
Okay.
is stemming from a theft charge. I think it's more constructive for him to get a job and earn money and pay the fine.
Understood, Judge. So we're prepared to move forward with the plea as negotiated this morning.
All right. Mr. Scott, may I place you under oath? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Thank you. Ms. Falk, what's the recommendation?
Yes, Your Honor. The state's recommendation in this case is going to be 12 months served 24 days, credit for time served 12 days. That's going to be from September 24th to September 26th of 2023 and March 12th to March 21st of 2024. Balance probated, 40 hours of community service, anti-theft course, stay away from 1217 Metropolitan Parkway. Count 2, the willful obstruction will be 12 months concurrent with count 1 and a $300 fine. The state would ask the defense to stipulate to venue, factual basis, and identification for the purposes of the plea. That's all for the state.
We do stipulate.
All right. Mr. Scott, have you consumed any medicine or alcohol recently?
No, ma'am.
And have you understood the proceedings so far?
Yes, ma'am.
Are you satisfied with your attorney?
Yes, ma'am.
And is yes or no?
Yes, ma'am.
And is anyone forcing you or inducing you to take this plea today?
No, ma'am.
If you decide to plead guilty to these charges, you would have to give up your constitutional right to a trial in front of a judge or a jury. You will not have the assistance of counsel to confront your accuser, to challenge the evidence brought before you, present any defenses and arguments, and have the state prove the charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
How do you plead to one count of theft by shoplifting?
Yes.
How do you plead to one count of willful obstruction of an officer?
Yes.
On the shoplifting charge, your sentence is 12 months to serve 24 days, credit for time served 12 days. Your jail time is concluded, but if you have no other holds, you shall report to probation on Monday before 3 p.m. Probation office is located at 132 Mitchell Street in downtown Atlanta. While you're on probation, you will complete 40 hours of voluntary community service. You must begin by completing at least 5 hours per month and 5 months every month thereafter until the 40 hours are completed. You may do that at any nonprofit agency that's not a church and not a school. Do you understand, sir?
Yes, ma'am.
You're also to complete an anti-theft class. You must enroll in that class within 60 days of being released. So as soon as you're released, you will need to make steps to make sure that you enroll in the class, because by your third probation visit, you must show proof of enrollment. Do you understand?
Yes, ma'am.
For the willful obstruction is 12 months concurrent with count 1 and is a statutory $300 fine. You shall pay that fine beginning with at least $5 per month at least within 90 days of being released. So I'm giving you 90 days to get a job, and then the first payment must be within 90 days. It'll start with $5. Then after that, you just need to make your payments until the $300 are paid off, including your probation fees and any surcharges. Thank you.
Thank you, Judge.
Your Honor, just to put on the record, the address of the stay away is the Chevron gas station.
And I'm so sorry, I forgot that. It was the, yeah, he needs to stay away from the Chevron gas station at 1217 Metropolitan Parkway.
Thank you, Judge.
Okay, and the bench warrant is null crossed. Who do we have, Ms. Vigiletti?
Judge, go ahead.
Position number 27 on the SAP calendar.
Okay, thank you.
This is
The
Mr.
last one is 24 CR 1109J, accused of theft by shoplifting from February 29, 2024. Mr. Swan, you've been advised of your right to remain silent, and your attorney is Ms. Vigiletti. You have another open case that's going to be addressed today, and that is 23 CR 3924J, also for one count of theft by shoplifting.
Judge, I believe that one is theft by taking. I think that might be a mistype on the calendar. When I pull it up in Odyssey, it's a theft by taking, and the facts are consistent with a theft by taking.
And also, Your Honor, I had represented Mr. Swan on another case. I just wanted to put that out there.
I'm so sorry, I was not aware, Ms. McLeod.
Yes, but it's a different case, so I don't know if the conflict still exists.
Okay, I do believe that our office is representing him on his felony case.
Okay.
You're not representing him on his current felony, are you?
No.
So yeah, I didn't check because our office, was already representing him.
Oh, I actually represented him on the SCA.
Oh, okay. Well, my request today was just going to be to reset to Tuesday, so maybe that'll give us time to figure out if he should come back to you anyway.
Yes, because he was arrested. He appeared on the 9th of March, and I represented him then.
I'm going to reset Mr. Delano Swan's case to next Thursday. Given the nature of the offer, I don't think that's going to prejudice the offer that's been presented by the state. It will be next Thursday, and we will reset 24 CR 1109J and reset 23 CR 3924J. That by that time, maybe we'll also clarify. I can't pull up that case, so just to correct the calendar.
I will enter appearance on his new case, Your Honor.
Okay. And meantime, also, the offer was for him to be on probation, but I'm not sure whether he'll be able to fulfill those terms if he has any felony holds. So please take that into account, and we'll address both cases on today's the 21st, so it'll be March 28th.
Thank you.
Ms. McLeod, I'll send you an email later today with what we talked about. Sorry about that.
Okay, great. No problem at all.
All right. Miss Hovanik, Deputy Milton at ACDC. I see her back there, so I just don't know.
Yes, Your Honor. Good morning.
Good morning. Ms. Hovanik, we have a gentleman who is at the Zoom panel, Fulton ACDC. The deputy had to remove him in order to get other folks into the room. So if you could please hold, as soon as he appears, we will try to get you and defense counsel and the defendant into a breakout session to confirm.
Okay, Your Honor.
All right, thank you. All right, jail court iPhone, who do we have, please?
We have position 4 and 5. They just came back from the breakout session.
Your Honor, thank you for the opportunity to speak to Mr. Brewster. That's position 4, 5, and 6, I believe.
Yes.
At this time, we're going to enter a plea of not guilty And I will file the appropriate paperwork, so it just needs to be transferred to a jury, trial to division, Judge.
All right. And will you be filing a waiver of arraignment on, and a
I will.
not guilty plea? Okay.
I will, Judge, on both cases, Judge.
Okay, this is Mr. Carlton Brewster. You have a right to remain silent. Anything you say in open court, your statements can and will be used against you. And your counsel is Mr. Jawan Haddad as appointed counsel. You have 3 separate cases. 21 CR 4694D, accused of simple assault and criminal trespass, and 23 CR 4729D, accused of battery. No, those were no, sorry. So sorry, Mr. Brewster. Let me correct that. That was the wrong case. Your second case is 21 CR 1526A, accused of simple battery, family violence from March 29, 2021. You also have a bench warrant, which is 24 FTA 261. These are the 3 cases brought against you, and your attorney has filed a waiver of arraignment and a not guilty plea on your behalf. So the cases will be further noticed for trial. Thank you.
Right.
Thank you, Judge.
Hello, I'm Miss Parent.
Your Honor, Ms. Stevenson is the alleged victim on the first case. She's the mom.
Yes, Mr.
Hi.
Stevenson. Yes, sir,
How
ma'am.
are you doing, Your Honor?
Doing well, thank you.
I am the victim and I wanted that dropped. It was over some chicken wings that was being cooked. My son has a diagnosis. I wanted to speak to you in your chambers. I don't know if they did. They said they did an eval for him, and he's had this illness 7 years. We've been dealing with this. And he's really not aware of the things that is happening before him. He needs to be in a facility where he can get help, not the jail.
Okay.
He needs his shots. He doesn't look well right now. All right, CJ.
All right. Ms. Stevenson, I am
Yes.
I'm going to ask you to speak to the Victim Advocates Division, which is also part of the prosecutor's office. Unfortunately, the decision to move forward with the prosecution is with that office, is not necessarily with you. If you are expressing a desire to not pursue any charge.
I already told him.
Okay, so that would be a decision that the prosecution would have to make. Now that you have indicated that there may be some MH issues, the counsel for his public defense attorney will definitely look into that to see whether there's a need for evaluation and or if treatment is required. So
They already did an eval on him in the
Okay.
jail. That's what they said, but
All right.
he had called me, but he never called me back to give me the conclusion, which I have an eval here at the house.
So that would
his
be
diagnosis.
that would be a decision entirely between Mr. Brewster and his attorney. If they decide not to share any information with anyone, that's entirely up to them.
Okay, so what is the conclusion of today? What did you say?
He has entered a not guilty plea, and his
Mhm.
cases will be scheduled for trial.
When?
We don't have the dates right now, ma'am. It has to be assigned to the division judge, and then the judge will provide the calendar date.
And he needs a mental judge.
Well, right now, he's not assigned to mental health court. He has a regular division court.
I wonder why.
Your
I
Honor,
have no idea.
He needed what did he say?
Ms. Stevenson, I would recommend that you please contact the Victim Advocates Division to get more information. You cannot share his private medical information in open court.
Oh, okay. Well, that guy was trying to say something, I guess.
And I'm going to let him speak, but I just need to understand if you have any other questions.
Okay, I appreciate it, Your Honor.
Okay, thank you. Mr. Haddad?
Judge, if Ms. Stevenson knows how to use the chat, if she can enter her phone number, I mean, I obviously, she brought up some issues. I would be happy to speak to her about her son.
Okay,
Needs.
Ms. Stevenson, are you familiar? All right, she's muted right now. All right,
I'm unmuted.
all right. Do you know how to use the chat feature?
Let's see here. Yeah.
Okay, when you click on chat, you need to choose courtroom 2.
It says sent to anyone.
No, don't send it to anyone. Send it to courtroom 2.
Do I match the tab?
You need
And
to
say
click on
courtroom 2.
Yeah, click on that.
Court.
Your Honor, I think that's okay. I think
Okay.
the number.
All right. Don't worry about it, Ms. Stevenson. The defense counsel has your number. Thank you, Ms. Maldonado. Okay, Ms. Stevenson, you're free to go. Jail court iPhone, we are concluded.
Thank you.
Thank you, Ms. Maldonado.
Okay, Deputy Milton, our Spanish interpreter is on Zoom.
Okay, let me,
Whenever-
if you don't mind, please, let me do Ms. Fields first. And then I'll go back downstairs and get him. Ms. Fields, come on.
I'm so sorry to interrupt. Very quickly, could I just ask Officer Gozi, is Mr. Tyson perhaps going to be next? I'm just asking because I have a character witness with a little bit of a time limit that's on.
We will have to hold on that. If the witness is unable to stay, then they can leave.
Okay, thank you, Judge.
All right.
All
right. Who has Miss Fields?
I do, Judge. I was unable to speak to her yesterday. I just needed a couple of minutes. I think we can resolve the case this morning, Judge. I just want to run some things by her.
All right, Deputy Milton, you probably have to mute ACDC. And are you ready to speak to her now, Mr. Haddad?
I am, Judge.
All right.
Okay.
All
You
right.
need a number, sir?
No.
No, we're going to put you in a breakout.
Thank you.
All right. Go ahead, Mr. Haddad. And Ms. Strong, if you could put Mr. Haddad and ACDC in a breakout, please. Thank you. All right. Ms. Vigiletti, if you want to address your next client, the person with the character witness.
He is one of the clients that Officer Gothi is going to have to bring the phone to, so I think we'll have to wait.
We have someone on jail court iPhone. Who is that?
This is position. This is position number 19, Mr. McGee.
Position 19, Mr. McGee. Mr. McLean, is that your client?
He is my client.
All right. William McGee is at the jail court iPhone. Mr. McGee, my name is Judge Law, and you have a right to remain. Can you hear me, Mr. McGee?
Yeah, I can hear you.
All right. My name is Judge Law, and your case is 24 CR 001093C. You're accused of simple battery, family violence from March 6, 2024. You have a right to remain silent about the facts of the case. Anything you choose to say about the facts, your statements can and will be used against you in the treatment of your case. You have a right to an attorney if you cannot afford one. Mr. Michael McLean will be representing you. Can you see your attorney on the screen? Mr. McLean, if you could please wave your hand.
Yes, sir.
All
Yes,
right.
ma'am.
And I understand this is going to be a not guilty plea and a bond modification request. Would
Yes,
that be
Your
correct?
Honor.
All right.
Well, I haven't heard any offer from the state or anything like that.
All right.
That's
This is William McGee. Miss Falk, would you like to articulate a offer on the record?
Yes, Your Honor, that would be fine. The state's offer is 12 months probation, serve 90 days, credit for time served 15 days. That's from March 6th to March 21st of this year. Balance probated ADET, which is an alcohol drug evaluation and treatment, 40 hours of community service, no further contact with Edith Bergeron, Family Violence Intervention Program, stay away from 835 Ayrshire Circle, and no firearms. That is the state's recommendation.
On the detail of the state's recommendation, he is correct. He was missing some information that I did not provide him yesterday. Thank you for that. I do need to go on, I need to ask him if he needs a breakout to discuss the detail that was left out.
Yes, sir, I do.
Okay, let's do that, Your Honor. I'll, at the appropriate time.
Do you have a device that you can log into?
I do. I can be logged in about 1 minute. I'm hitting Zoom now and hitting join meetings.
Miss Falk, can I place you in a breakout with Miss McLeod?
Yes, thank you, Your Honor.
Miss
I was
McLeod?
hoping this would be kind of a good break for us to go in there.
Okay. Miss McLeod and Miss Strong, if you can place Miss Maureen McLeod and Miss Shelley Falk in a breakout session. And as soon as Mr. McLean joins the Zoom, Deputy, we can mute courtroom 2, please. Thank you. All right. Ms. Strong, if you could place Mr. McLean and Jail Court iPhone in a breakout session, please. All right, Mr. Haddad, we are addressing your client, Ms. Fields.
Yes, Judge.
All right, this is, yes, sir. And what's your announcement?
Your Honor, my client she wanted to resolve the case. I want to see if she's eligible for a no contest and nolo plea. The state's recommendation is time served, Judge, and she wishes to resolve it. There are some factual issues, which is why I'm asking for a nolo plea if she's eligible.
All right, just 1 second, Mr. Haddad. Mr. McLean, you'll need to be in a breakout session with the jail court. Is he just frozen?
He is, Judge. I hear him.
Okay, you do? Okay, thank you. Let me see, Mr. Graham, does the state have any objection to a nolo she's accused of criminal trespass and willful obstruction of a law enforcement officer under case 24 CR 939A. And Ms. Fields, please remember you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and Mr. Haddad's your counsel. Mr. Graham?
Your Honor, if you can give me just 1 moment, my Odyssey also just kind of went out. Just 1 second, please.
And Ms. Tyson, if you happen to have Ms. Shonda Fields, GCIC, please.
Yes, Judge. 1 moment. Just 13 arrest cycles. You want her history? Is that
Yes,
what you want?
please.
Okay.
Mhm.
13 arrest cycles beginning in 1990. Her last arrest was, let's see. Was in Atlanta, May of 2016, and that was for possession and use of drug-related objects. She does have a felony conviction outside of the 10-year period, and that's for robbery. That was in 2010 out of Richmond County.
Oh, that's good then. Thank you. Mr. Graham?
My apologies, Your Honor. I was just trying to take a look. And just to be clear, the defense recommendation, or the request is for Ms. Fields to enter a nolo plea.
Yes, to enter a plea of nolo contendere to criminal trespass and willful obstruction with the offer of balance suspended after serving 48 days, credit for time served 24 days, and to stay away from the Starbucks, which to some people in itself is already a huge penalty.
Yes, the state has no objection, Your Honor.
All right, Mr. Haddad, there's no objection to, where's Mr. Haddad?
Right here, Judge.
There he is, okay. There's no objection to a nolo contendere.
All right, thank you, Judge. We're ready for a plea.
All right, Shonda Yvette Fields, Deputy Milton, if you could unmute, please. Ms. Fields, the state is in agreement that you can enter a nolo plea to the criminal trespass and willful obstruction of an officer. Would you like to proceed?
Yes, ma'am.
All right, you'll need to speak up a little louder, okay?
Yes, ma'am.
Thank you. Ms. Fields,
Ma'am.
I've advised you of your right to remain silent. Your attorney is Mr. Haddad. This is going to be a plea hearing on the criminal trespass and willful obstruction of a law enforcement officer. May I place you under oath for purposes of the plea?
Yes, ma'am.
Please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Mr. Graham, go ahead.
Thank you, Your Honor. The state's recommendation is 12 months, served 48 days, credit for time served 24 days. That's from the period beginning February 27, 2024 until today. Balance suspended, stay away from 2345 Peachtree Road in Atlanta, the Starbucks. And on count 2, 12 months, balance suspended as well. And the state will accept the nolo plea.
All right. Mr. Haddad, do you stipulate to the factual basis, venue, and ID?
We do for purposes of the plea, Judge.
Thank you. Ms. Fields, have you sorry, Deputy Milton, thank you. Ms. Fields, have you consumed any medicine or alcohol recently?
No alcohol medicine, ma'am.
All right. Are you still able to understand the proceedings?
Yeah, yes, ma'am.
Are you satisfied with your attorney?
Yeah, yes, ma'am.
And if you decide to plead guilty, no contest to these charges, you would have to give up your constitutional right to a trial. You won't be able to confront your accuser, challenge the evidence brought before you, and have the state carry its burden to prove the charges beyond a reasonable doubt. Are you?
I stay away from the Starbucks that I'm not able to go to, right? One on, right?
And not only would you have to waive your rights, but yes, you will not be able to go back to the Starbucks at 2345 Peachtree Road. Are you
Yes, ma'am.
willing to give up your rights to a trial?
Yes.
And are you willing to stay away from the Starbucks at 2345 Peachtree Road?
Yes, ma'am.
Yeah. How do you plead to the criminal trespass and willful obstruction of a law enforcement officer?
No logo.
All right. I'll accept your nolo plea to both charges. Your sentence is 12 months to serve 48 days. Credit for time served 24 days. Balance suspended. Stay away from that Starbucks location.
When do I get out, ma'am?
Within 24 hours.
Yes, ma'am. Thank you.
Your Honor, she does have a hold for Sandy Springs.
Is it a traffic matter?
It says,
I
it
don't
just says
drive.
failure to appear. It doesn't give me any other additional, just says a failure to appear.
Yes.
Oh, okay. Then Miss Fields, you'll have to wait for Sandy Springs to come pick you up.
Ma'am.
Do you have
Ma'am.
an outstanding charge in Sandy Springs?
No, ma'am. They had the sheriff had brought me down, shut me on a van down here with a snap. I don't have no hold on me at no Sandy Spring. They brought me over here to this Fulton County jailhouse from Sandy Spring. I had a hold on me.
The Fulton County Jail, before
This
they
is Fulton
release-
County here.
Listen very carefully. The Fulton County Jail, before they release you, they're going to contact Sandy Springs. And if they confirm that they do not need to pick you up, then you will be released.
Well, if they do send me back to Sandy Spring, when do I get released, ma'am?
When Sandy Springs release you, you're done with Fulton County. You don't have a case anymore.
So what kind of case I got in Sandy Spring and I don't supposed to go to Starbucks, ma'am? I'm confused.
The only
Why
thing
would I have to go back to Sandy Spring?
Yep. Like I said, the jail's going to confirm.
Could you please tell me what's going on as my lawyer? Hold on.
Mr. Haddad, are you familiar with her Sandy Springs hold?
No, Judge, and I can't get any information because it's just the hold.
They trying to run me back to that dead body.
All right. If you want to keep talking like this, Miss Field, no, you need to be quiet now. You need to be quiet so we can look into it.
Your Honor, I will look at it once we're done with court, try and find out. It could be that it's a mistake, Judge, because she was brought from Sandy Springs, but I'll follow up on it.
Okay.
Thank you, Judge.
All right. That concludes Miss Field's case.
Thank you, Judge.
All right. Deputy Milton is going to bring Miss Vigiletti's client who needs a Spanish interpreter, and then we're going to put them in a breakout session. And Mr. McLean, have you had a chance to speak to your client, Mr. Williams?
Mr. William McGee.
McGee, excuse me, Mr. William McGee. Yes, sir.
Yes, Your Honor. He wishes to go pro se, and he's unhappy with the fact that in state all purpose, we can't bring him a proper investigation of the case with videos and 911 transcriptions and that sort of thing. And I agree with him. I will join in his protest, so to speak, as long as it's civil. And he wishes to go pro se and address the court asking for a signature bond.
All right.
Thank you.
This is case 24 CR 001093C, State versus William McGee, accused of simple battery family violence from March 6, 2024. Mr. McGee, you have been advised of your right to remain silent. You were offered the opportunity of appointed counsel with the Public Defender's Office, as is your constitutional right if you cannot afford an attorney. You also have a right to hire your own private attorney if you choose to do so. You also have the right to waive your right to counsel and proceed self-represented. In other words, to represent yourself. But please keep in mind that if you choose to represent yourself, you are responsible for understanding the criminal laws and criminal procedures as they apply to the facts of your case. You are responsible for the consequences and ramifications for any legal decision that you make, including the impact upon the issues of guilt or innocence, and on the issue of your bond, and on the issue of detention. So, would you like the advice, the assistance, and the professional help of a legal attorney? Or would you like to represent yourself?
Listen, yes, ma'am. Judge,
Yes, ma'am. Which one? You want an attorney or you don't want an attorney?
I would like to say what I have to say with his assistance from the legal standpoint, as far as protocol of what I need to say and how I need to say it.
So do you want Mr. McLean to represent you?
I want to represent, he doesn't know anything about this case. I do. And what I'm saying is, I want someone with knowledge to be able to talk to you about the circumstances.
If you give Mr. McLean an opportunity to investigate, then I'm sure he'll be able to speak with you with more knowledge of the case.
Well, no one has contacted my mother. All right. And I'm her caretaker and she's ill. And so this situation is a little bit touchy, Judge. In other words, it's not going to benefit me or her or anyone else for me to be in here when I'm the person who sees about her. She's 83 years old. All right. And they've charged me with something that's not ethereal. It's not even a, what is a smush? And so I'm trying to get this thing straightened out. My job started the other day at the beginning of March. It's seasonal work. And I need to get to work. I need to get over there. She told me yesterday I need to come and cut her grass. You know, so what I'm saying, Your Honor, is that this thing it's an illness that we're dealing with, not a crime. And I wish the court would allow the parties involved to get together and find a solution to this problem.
Let me cut
Mr.
to the
McLean?
chase, Your Honor, if I might, on summarizing some facts. I understand, well, I have no personal knowledge, obviously no firsthand knowledge. I understand that he says he called 911 when his mother cut him. The police arrived. They investigated by asking people what happened. And when they talked to him, they heard that she cut him. When they talked to her, she said that she didn't want him arrested. And then he says the police asked his mother, who was undergoing a dementia episode, they asked his mother if he had touched her, and they asked a leading question about did he smoosh her. Now, I've heard the slang term mooshing somebody, which means to touch them or slightly push them or something like that. I've heard that term before since coming in.
I'm just telling you what's in the warrant. The warrant says by open hand striking her in the forehead with his palm during a verbal dispute.
Right.
That is the extent of the alleged physical violence.
Right, I was aware of that, Your Honor. So his point is that he believes a signature bond would be in order. However, the point he's making about needing to go cut her grass and needing to go take care of her, the court would have to consider whether to allow that. And of course, he is requesting it.
All right, Ms. Falk, there seems to be a request for a signature bond.
Your Honor, I will point out that this is the defendant's second case involving the same victim. There is a 20 CR 003551D case that was dismissed for simple battery family violence. That allegation was that he struck Miss Edith Bergeson. And so this is, for us, there is some concern here in regards to previous events involving the same victim that leads us to request that this not be a signature bond. Additionally, and just to go through his history, I believe, if I am correct, this defendant has a number of cycles. I don't want to speak out of turn, so let me just pull that up really quickly. 64 cycles to be precise. And there are cases, at least in Fulton County, for disorderly conduct. I'm seeing, just kind of briefly going back to 2018, there was a terroristic threats and acts case that was null prost, an aggravated assault case that was null prost. Let's see, conviction for theft by shoplifting in 2015. I'm showing a possession of drug-related objects that was recently, that was actually May of last year. Let's see, what else am I seeing? Going back a little further,
That's quite adequate. Thank you.
Right.
All right. Anything else to add, Mr. Williams? If you still choose to waive your right to remain silent and waive your right to counsel?
Yes, ma'am. This is what I want to say to you about that. What she just said is that we've been going through this same situation. The previous case that she just referred to that was dismissed, it took them 2 years to dismiss it. The court resolved and found that she was going through this dementia thing. We've been dealing with this for 10 years. She's a chronic diabetic that does not take her medication. She has hyperglycemia. And when she goes through certain things at certain times of the day, she gets all the way out of control. And that's what happened again the other day. And what I'm trying to tell you is, so it took them 2 years to figure that out last time. 2 whole years. Okay, so the other thing I want to say is about my record. That I'm 67 years old now. She's talking about things I haven't been in prison or in convicted of a felony since 2000. You understand? I'm there seeing about my mom. I got a wife and kid. I just sent them to Seattle. I'm broke because they just left February the 24th. I'm right ready to go to work at the beginning of March, and then this happens. You know, it's a situation where she's not doing her medication. She's refusing certain things. The family is trying to get her some help, get her some in-home care, take care of her. But in the meantime,
Mr. Williams, I've already read the prior case and I'm hearing you, and I think we've lost him. Okay. Let me see. Ms. Hovanik, we're still waiting on that. Ms. Vigiletti, are we ready with any of your cases?
I believe that we were waiting for Jairo Vasquez Lara from ACDC to return, so we can.
Yeah, I'm waiting on that. All right, and so while I'm waiting for Mr. Williams to come, Mr. McGee to come back on, Ms. Falk and Ms. McLeod, have you discussed Ojeris McGee?
Yes, Your Honor. The state would ask for a 1-week reset on that case. We need to speak with the, essentially what I have explained to Ms. McLeod is we need to speak with the family of Mr. McGee to see if there's any place that Mr. McGee can stay or any housing that they're aware of for a potential bond. The state's not agreeing to a bond, but we need to at least figure out if there's a place he can stay in the interim. I know Ms. McLeod also wants to look into a potential solution for where he would be so that he is not staying with the victim, in this case, Mr. Olin McGee.
All right. Ms. McLeod, I was actually going to arraign the case and have all 3 cases before Judge Porter, as she seems to be very familiar with this, and then y'all can address it on April 25th. But if
It can be arraigned also, Your Honor, but at the same time, I think if we can have some kind of resolution by next week, it's better, because have him sitting in there in jail until another month is not going to be good for him.
All right. If you could file a waiver of arraignment, and we will further notice the case for trial. And this case, position 18, is reset to March 28th at 9 a.m.
Thank you, Your Honor.
All right, thank you.
I will file the waiver.
All right. Was that your only case this morning?
No, Your Honor. I
Okay, 11
also
o'clock?
have Mr. Bustle.
Okay. All right. Okay, we'll be right with you. I'm so sorry. I'm multitasking with different cases which have to take breaks in between. Okay. All right, Mr. William McGee, like I said, I've heard your argument. I've read the previous case and the reasons why it was dismissed. I don't think there was any judicial findings as what you claim to have. I'm also reading the warrant that was issued in this new case, and there are quite a few disturbing factors. So if you would like Mr. McLean and the Public Defender's Office to represent you, I'm sure they can get into the information such as the investigator's report, the body cam footage, and so forth, as well as consider any interviews with the alleged victim. As you indicated, if you want your attorney to have more information about this case, they would need to have the opportunity to investigate the matter. Now, if you're also asking for a bond modification, I'm willing to reduce that to a $1,500 surety bond. Your criminal record history and the nature of that warrant do not qualify you for a signature bond. Now, Mr.
You're going to reduce the bond.
Just a minute. So, Mr. McGee, do you want the services of the Public Defender's Office, or do you want to represent yourself?
Yeah, yes, ma'am. I want him to argue for me, but I know he doesn't know anything.
Give me a straight answer.
Yes, ma'am. Okay,
Thank you.
yes, ma'am.
Thank
Yeah,
you.
all right, I'm sorry.
Mr. McLean, you are counsel or the Public Defender's Office is counsel of Mr. McGee's case. Mr. McGee is seeking more information. So do you want me to reset it to next week, March 28th? Or would you like me to consider an arraignment today?
Your Honor, the former.
Okay.
Let's do the reset.
We're going to reset this case to March 28th, 2024 at 9 a.m. And perhaps Mr. McLean will have additional information that would assist in Mr. McGee making a decision as to whether to plead not guilty and have the case arraigned.
Thank you, Your Honor. Mr. McGee, I will call the number you gave me and inform that person that maybe they should start trying to make your bond. Thank you.
But okay, Your Honor.
Let's talk later. Let's talk later alone.
Please, Judge, I wish they would have the prosecution to listen to the 911 call.
You've already mentioned that. And
they need to do that. That will clear everything up.
All right,
I
Ms.
promise
Fault, you've got
All
that
right.
request. Thank you.
All right, thank you. Hey, thank you, lawyer. I appreciate you.
All right.
All right. Deputy at Jail Court iPhone, do you have another case there?
I do, but this phone is about to die. We're probably like,
All right.
any minute. So we're gonna bring them probably down to 3 South or to medical.
All right. Okay. Thank you, sir.
Yep.
Deputy Milton, do we have the gentleman here for the interpreter case at ACDC? I don't know where she is.
We can go to position number 6, 7 on the SAP calendar.
7? Okay.
And 7.
I'm sorry, repeat, Deputy?
6 and 7.
6 and 7. Okay, thank you. This is 23 CR 4729D, State versus Quentin Russell, accused of battery from July 26, 2023. And, excuse me, not Russell, Bussell. And Mr. Bussell has a bench warrant, 24 FTA 000262 from August 4th, 2023. Mr. Bussell, you've been advised of your right to remain silent, and your attorney is Ms. Maureen McLeod. Ms. McLeod? Ms. Maureen McLeod?
Yes, Your Honor, I'm here.
All right, thank you. We have your client, Mr. Bussell, in courtroom 2.
Yes, Your Honor.
All right. How would you like to proceed?
This is going to be a non-negotiated plea, Your Honor.
Okay. Mr. Bussell, if you please raise your right hand, we're going to just swear you in for purposes of a plea. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
I do not.
Thank you. All right, Mr. Graham, who is the prosecutor, is going to give me his recommendation for a plea, in exchange for a plea of guilty, and your attorney is going to give me an alternative recommendation. I will let you know which one I will opt for before you can decide whether you want to proceed. Mr. Graham?
Thank you, Your Honor. So this incident took place July 26, 2023. Law enforcement responded to the Best American at 5021 Old National Highway. They met with Echelon, ECHLON Trimble, in the rear of the Red Snapper to take the report. She told the officer that Quentin Bussell, her boyfriend of 1 week, struck her in the face during an argument. He had asked her for drugs and became angry when she told him she didn't have any. He swung on her 3 times, striking her in the face, and then took her money before running off. The officer did observe swelling above her right eye and a cut that was bleeding on her top lip. State is recommending 12 months, serve 60 days, credit for time served 16 days. That includes a period from July 31st, 2023 through August 1st, 2023, and March 8th, 2024 until today. Balance probated, ADET, 40 hours of community service, FVIP, no further contact with Echelon Trimble, and a no pros for position 7 for the FTA for a plea to position 6.
All right. Ms. Tyson, may I have Mr. Bussell's GCIC?
Yes, Your Honor. 10 arrest cycles beginning in 2005. Did have a felony case out of Clayton County for purchase, possession, manufacture, distribution, or sale of marijuana and theft by receiving stolen property. He received first offender treatment on that case December of 2010, and the case was sealed in 2017. He has a felony conviction out of Rockdale County for robbery. That's from September of 2017. He has an FTA from 2017, and his last arrest was in Rockdale County, March of 2022, and that was for a violation of probation. He has a total of 4 violations of probation, Your Honor. Nothing to add.
That was March of 2022.
Yes.
Okay. This allegation was from July 26, 2023. Okay. All right. Ms. McLeod?
Yes, Your Honor, we are okay with everything that the state is recommended, except the amount of time, Your Honor. My client tells me that he was essentially homeless, and that's how he missed court. We had filed a waiver for arraignment, anything, and I had actually appeared on that calendar, Your Honor, at the time when the bench warrant was issued. This case was before Judge Eatlin, I believe. He tells me that he has a few belongings that he was not able to secure at the time he was arrested, because he was at a McDonald's restaurant when the police ran his information and found out that this FTA warrant was there. So he does not object to the probation, to the community service, and the ADT, Your Honor. It's just that he would like to get out earlier, if possible, today.
Doesn't have a very good track record where probation is concerned. That's my concern. I'm also very concerned about his ability to complete the domestic violence intervention program if he is homeless and indigent.
Yes. And Your Honor, he also denies that they were in a relationship or anything like that. I think she said a relationship of 2 or 3 weeks. He says that is not true. It's just someone he has seen around the place, but they were not in a relationship, Your Honor.
Then you should definitely go to trial then instead of pleading guilty. If he wants to challenge the elements of the crime.
Your Honor, he's not challenging the elements of the crime. He's just saying, you know, that that's a situation. He's willing to plead guilty.
Oh, I'm so sorry. This is not battery family violence. All right. So, I'll dispense with the family violence intervention. The charge is battery. I'll require 12 weeks of anger management classes, but he'll have to do the jail time given his very spotty record on probation violations. He has not been very good about complying with probation, so I'm going to require him to do the additional jail time. So, Mr. Bussell, I'm willing to remove the domestic violence intervention program, since that is, I don't see the benefit of that, since you're not in a romantic relationship apparently with this person. You do not live with that person, and you do not have children with that person. But and I'll convert that to 8 weeks of anger management classes instead of a 24-week program. But you'll need to do the additional jail time. Would you like to proceed with the plea, or would you like to enter a not guilty and have the case scheduled for trial?
I'm going to proceed.
I'm sorry?
I'll proceed.
All right. Ms. McLeod, anything to add?
No, Your Honor.
Do you stipulate to the factual basis, venue, and ID?
Yes.
All right. Mr. Bussell, have you consumed any medicine or alcohol recently?
No.
All right. Just 1 second. ACDC, do we have the gentleman ready to speak with our interpreter?
You're welcome. Have a seat.
All right. Miss Vigiletti, are you able to get onto a device?
Yes, I'm on. I should be called Olivia. Let me unmute my screen.
It's on, it says it, I see it.
Okay. Ms. Strong, could you please place Miss Vigiletti and ACDC and Miss Hovanik into a breakout session, please?
Thank you.
Thank you. All right, as I was saying, Mr. Bussell, are you satisfied with the legal services you've received?
Yes, ma'am.
All right. I've got my volume at the highest. Could you speak up a little bit more, please?
Yes, ma'am.
Thank you, much better. And have you understood all the proceedings and the court's decision on the accepting the recommendation?
Yes, ma'am.
Are you entering this plea freely, willingly, and knowingly?
Yes, ma'am.
If you decide to plead guilty, you would have to give up your constitutional right to a trial in front of a judge or a jury. You will not have the opportunity to have your attorney with you in a court of law, to confront your accuser, challenge the evidence brought before you, present your evidence of defenses, mitigating factors, and arguments, as well as have the state carry its burden to prove the charge against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
How do you plead to one count of battery?
Guilty.
Your sentence is 12 months to serve 60 days, credit for time served 16 days. After you've served the additional time at the jail, you'll be released and placed on probation. You must report to probation on the first business day before 3 p.m. and at 132 Mitchell Street in downtown Atlanta. While you're on probation, you will complete an alcohol and drug evaluation and submit yourself to any treatment. You're not allowed to consume any illegal drugs and no alcohol consumption while you're on probation. You will be subject to random screens. While on probation, you will also complete 40 hours of voluntary community service with any nonprofit agency, and you must begin with at least 5 hours per month and five hours every month thereafter. Instead of a domestic violence class, you will complete 8 anger management classes, and you may begin those classes within 60 days of being released. At all times, you are to have no further contact with Ashelon Trimble. That concludes your sentence. Thank you. All right, Ms.
Thank you, Your Honor.
All right, thank you. 3 South, who do we have, please?
Add on position number 5, Mr. Gus McKinney.
Mr. McLean, is that your client?
He is, Your Honor.
Okay. This is State versus Gus McKinney. Mr. McKinney, if you please sit up straight. Thank you. Your case number is 24 CR 1023A. You're accused of battery, family violence from March 3rd, 2024. You have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and representing you is Mr. Michael McLean. Mr. McLean, if you please wave your hand. Mr. McKinney, do you see your attorney on the screen?
Yes, ma'am.
Thank you. And Mr. McLean, how are we proceeding?
Your Honor, with an unnegotiated plea.
All right. Mr. McKinney, for purposes of the plea, may I place you under oath? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Thank you. All right, Ms. Falk, what is the recommendation for Mr. McKinney?
Your Honor, the state's recommendation on this case is going to be 12 months probation, 45 days to serve, credit for time served 19 days. That's from 3/13 to, 3/21. Let me just make sure my calculation is correct on that. Yes, that would be correct. No further contact with Bryant Johnson. Stay away from 369 McDaniel Street, Atlanta, Georgia. 40 hours of community service, family violence intervention program, as well as no firearms. In this particular case, Your Honor, this incident happened on March 3rd. Officers were dispatched to a domestic dispute at 369 McDaniel Street Southwest, apartment 2406. They spoke with Mr. Johnson, who stated that he lives in the apartment with Mr. McKinney, Mr. Pollard, and Mr. Richardson in a program. He advised that while living in the apartment, there's a 8 o'clock curfew. If the individual comes in after curfew, he's not allowed into the building. Mr. McKinney left the apartment and came back around 10 p.m., began banging on the door, demanding that Mr. Richardson let him in. Mr. Johnson stated while he was in his room laying down on the bed, the defendant opened the door and jumped on top of him, grabbed him by his neck with his left hand, attempted to punch him with his right hand while holding a metal object. The noises woke up other people in the apartment. One of the individuals saw the defendant and broke them apart, the defendant and the victim. And after breaking them apart, the defendant took out his phone, called his sister, and said that he had been cut in his neck to grab the guns and make her way to the location, and then left the apartment. This incident, let's see, just to kind of go over the defendant's history. The defendant has cycles out of both Tennessee and Georgia. In this particular instance, the defendant's history out of Tennessee consists of 40, excuse me, sorry, I'm actually misspoke, consists of 91 cycles. I am not going to go through all the cycles, but there are a number of assaults and assault charges and battery charges. The defendant also has a history out of Georgia, and that history consists of, let me just pull that up if I may. I believe this may be his only case out of Georgia. Well, nope, that's Tennessee as well. So I believe this may be his only case out of Georgia, but let me just double check because I'm showing that he has previous arrests out of Georgia. So, but needless to say, with his history alone in Tennessee is much longer than a lot of the histories that we see here. And based on this, we are asking for this recommendation. Mr. Bryant is here and present in the courtroom. He did state he has some questions for Your Honor regarding the plea offer, but when we tried to reach out to him earlier, we weren't able to address those specific questions. So we would like to sound for Mr. Bryant Johnson.
So Bryant Johnson, if you'd like to unmute.
Yes, ma'am, Your Honor. How are you doing this morning?
Doing well, thank you. Please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
All right. I do not know what is going to be the final sentence if Mr. McKinney decides to move forward and plead guilty to this offense. But the state is asking that he serves additional time at the jail, that he has no contact with you. In other words, he has to stay 200 yards away from you, and he cannot communicate with you in any way, form, or manner, including through a phone, a computer, and on social media. He also cannot return to 369 McDaniel Street, with the one-time exception with a police officer to retrieve his belongings. He'll be required to do 40 hours of voluntary community service, a 24-week counseling program, and not be in possession of any firearms. That is the recommended sentence. Do you have any questions?
Yes, ma'am. There's a couple of questions that I have. I work here at a nonprofit organizations that let felons come in and do community service.
What's the location of this place?
It's 466 Northside Drive.
So if you work there, then you need to let your employer know that that he has a no contact, so he may not be allowed into the building.
Yes, ma'am. It's a drug program that I'm in. I've been here.
I understand, but if you are in that building, Mr. McKinney is required to stay 200 yards away from you. So
Yes,
that's
ma'am.
the length of 2 football fields. So unless
Yes.
you work in a very big warehouse that's 200 yards long, he's not allowed into any building that you occupy.
Yes, ma'am. As well as that, I don't want to see Gus get in any more trouble. I mean, we reached out to Gus and tried to help him as much as possible when he was in the program. I asked that if it's possible.
Mr. Williams, you work in such a program. Can you guarantee me that any convicted felon will not get into any trouble? At some point, they have to help themselves too, correct?
Are you speaking to me, Your Honor?
Yes, Mr. Johnson, I'm sorry, Mr. Johnson.
Yes, ma'am.
I
no,
cannot
ma'am.
guarantee that kind of outcome.
No, ma'am, but my question is that if we could have him to go to some kind of drug treatment facility on a inpatient basis, I think that would be helpful to him as well as to society.
Okay, I'll think about it. Anything
Yes, ma'am.
else?
No, ma'am. Other than that, I'm fine.
All right. Thank you, Mr.
Oh,
Johnson.
yes, ma'am. I do have one more thing.
Yes, sir.
The threats that he made some real serious accusations and threats about having guns come around.
One of the conditions is he's not allowed to own any firearms. And given the fact that he's got 91 cycles and he's a convicted felon, he's not allowed to own any firearms by law.
Yes, ma'am. But I mean, he notified family. That's what had me so worried. I mean, I'm looking over my shoulder because he did notify other people, other
Well,
parties.
he's going to be sentenced accordingly if he decides to plead guilty. In addition to that, you can also apply for a, this occurred on March 3rd, 2024. You can also apply for a protective order through Fulton County Superior Court if you believe you need an additional safety net.
Yes, ma'am. I've been advised of that, and I will do so on that.
Okay, yeah, it's not too long ago. You still are eligible to apply.
Yes, ma'am. Thank you.
Anything
That's all.
else?
No, ma'am, that's all.
Thank you. Mr. McLean, what is your recommendation for Mr. McKinney?
Oftentimes in a situation like this, the court and the prosecutor may be expecting me to contest the 4 extra days. His concern, he's got a hold out of state. The 4 extra days will be eaten up by waiting on them to pick him up. That's not his concern. He doesn't want to look like a schmuck by not doing the FVIP and the 40 hours. He doesn't want to have failure on his probation to be in his future. And he asked if there's any way for the court to delete that because he believes that he will be tied up with other incarceration matters for the next year.
We can wait for him, no problem.
And Your Honor, maybe I'm a little lost here. I see in the jail screen that he has a hold from Cobb County, but
Well,
not
to
out
some
of
people,
state.
that's considered out of state, but
Well, there's,
no matter where he goes, we'll wait for him.
he believes there's another one. That's okay. Thank you.
When I'm stuck in traffic in Cobb County, trust me, it's almost like traveling out of state. So, okay. Mr. McKinney, I am accepting the state's recommendation that you are sentenced to 12 months to 45 days, credit for time served 19 days, to have no contact with Bryant Johnson, stay away from the McDaniel Street location, do 40 hours community service, and while you're on probation, to enroll and complete the 24-week domestic violence program. And while you're on probation, not to be in possession of any firearms. While you're on probation as well, you're not to consume any alcohol and no illegal drugs, and you'll be subject to random screens. Your probation may commence as soon as you resolve any and all holds that you may have in any other jurisdiction. Would you like to move forward with this plea, or would you like to plead not guilty and have your case scheduled for trial?
Just get it behind me. I just like to get it behind me, Your Honor.
I don't understand hand signals.
Yes, ma'am. Yes, ma'am. I just like to get it behind me.
All right. Mr. McKinney, Mr. McLean, do you stipulate to the factual basis, venue, and ID?
Yes, Your Honor, we do for the purpose of the plea.
All right. Mr. McKinney, have you consumed any medicine or alcohol?
No, ma'am.
Again.
No, ma'am.
Mr. McKinney, you're not sitting and watching a movie.
No,
Please
ma'am,
sit
Your
straight.
Honor.
Thank you.
Judge, this chair is broken. That's why he's leaning back. It's
Lord
not-
help me. Okay, so sorry. Okay. All right. And Mr. McKinney, are you satisfied with the legal services you've received?
Was my attorney. Yes, yes. For as my attorney, yes.
Okay. And have you understood the recommendation for the sentence as indicated by the prosecutor?
But Your Honor, when I'm saying I may have a year and a half in Cobb County. Then I'm a resident of Chattanooga, Tennessee. I'm not a resident of Fulton County. I plan on moving back to Chattanooga out of state. How can I take something I don't even live in Atlanta? How can I report something I live in Chattanooga, Tennessee?
You will not be able to go back to Tennessee. You will have to come back to Fulton County and fulfill your sentence before you go back to Tennessee.
I got a
Understood.
hole in
All right,
Tennessee.
Mr. McKinney, in that case, then I'm just going to go ahead and reset the case for trial. If you don't believe you can complete this sentence, I'm not about to, waste any more time. I don't believe that you are committed to this sentence. I will arraign this case. Mr. McLean, do you waive a reading of the accusation?
Let me ask Mr. McKinney, do you understand what the judge's point is about? You have to do your dead level best to go to the FVIP and complete it if you take this sentence. Can you do that?
Okay, I can complete whatever, then come back and start the sentence. Okay, yes, sir.
Okay. And
Yes,
the
sir.
40 hours, was it 40? Was there 40 in this?
Yes.
I believe there was. And that's simply with a nonprofit, and you'll be able to do fine with the nonprofit. I think you can do it, Mr. McKinney.
Okay.
Got to have the right spirit and attitude and determination to get her done.
Yes, sir. So what? I got 4 more days to serve.
4.
Then they'll come get me for Cobb County.
Correct.
Okay, thank you very much.
Then come back to Fulton County. Okay. Mr. McKinney, as I was saying, have you understood the recommendation now that was provided by the prosecutor in exchange for your guilty plea?
Yes.
And are you entering this plea freely, willingly, and knowingly?
Yeah, freely.
Willingly
Yes.
and knowingly?
Yes, ma'am.
If you decide to plead guilty, you would have to give up your constitutional right to a trial in front of a judge or a jury. You will not have the opportunity to have an attorney and come back to court to confront your accuser, challenge the evidence and the witnesses brought before you, present any legal arguments, defenses, and mitigating factors if you choose to do so, and have the state carry its burden to prove the charge against you beyond a reasonable doubt. If you choose to plead guilty, you would have to give up these rights. Are you willing to do so?
Yes, ma'am.
You understand that this will be the final decision of the court and there's no right to appeal.
Yes, ma'am.
How do you plead to 1 count of battery family violence from March 3rd, 2024 involving Bryant Johnson?
Guilty.
Your sentence is going to be 12 months to serve 45 days, credit for time served 19 days. You have 4 additional days to serve at the Fulton County Jail, after which you will then be transported to Cobb County to address the outstanding matter there. Once you have resolved your outstanding Cobb County matter and released, you will immediately report to the Fulton County Probation Office and the first available business day. Your report will be to 132 Mitchell Street in downtown Atlanta. Failure to report can result in a revocation of this probation and an outstanding warrant will be issued for your arrest. But if you do report in a timely manner, you will be placed on probation. While on probation, you will not consume any illegal drugs and no alcohol, and you'll be subject to random screens. You will report every month. You will complete 40 hours of voluntary community service at any nonprofit agency that's not a church and not a school. You must begin with 5 hours per month and 5 hours every month thereafter. You will also enroll in a domestic violence intervention program, and you must enroll in that program within 60 days of beginning probation in this case. You must continue with those weekly classes with no breaks. At all times, you are to stay 200 yards away from Bryant Johnson, have no contact with him in any way, form, or manner, including in-person, mail, email, cell phone, computers, and social media. You are to stay 200 yards away also from 369 McDaniel Street in Atlanta, Georgia. That concludes your sentence. Thank you. Ms. Vigiletti, are we ready with your case at ACDC?
Yes, Judge.
What position number was that?
This is position 30 and 31, Jairo Vasquez Lara.
Ms. Hovanik? May I
Yes,
place
Your
you under
Honor.
oath? May I place you under oath? Do you solemnly swear and affirm that the information and testimony you translate will be a true and accurate translation with no changes and embellishments?
I do.
Thank you. This is State versus Jairo Vasquez Lara, who has two cases before us.
Este es el estado contra Jairo Vázquez Lara, que tiene dos casos ante nosotros.
Mr. Vasquez, you have a right to remain silent. Anything you say in open court, your statements can and will be used against you.
Señor Lara, usted tiene el derecho de permanecer callado. Cualquier cosa que usted diga puede ser usado contra usted.
You have a right to an attorney. If you cannot afford one, Ms. Vigiletti will be your appointed counsel.
Usted tiene el derecho de tener un abogado. Si no puede contratar uno, la abogada vigilante va a ser su abogada.
The first case, position 30, is case number 21 CR 5224Y.
Y el caso es la postura 30 21 CR 005224Y.
You are charged with driving while license suspended or revoked and 3 counts of willful obstruction of an officer.
Se le acusa de un cargo de manejar con licencia, ya sea suspendida o revocada, y 3 cargos de obstrucción a un oficial.
In addition, you have a driving on the wrong side of the road, fleeing and attempting to elude.
Y además, tiene aquí por manejar el sentido contrario y por tratar de eludir e huir.
And a 7th count of reckless driving.
Y a un séptimo cargo de manejar temerariamente.
This stems from an October 1st, 2021 incident.
Este es de un incidente del 1 de octubre del 2021.
Your second case is 21 CR 6741Y from November 20th, 2021.
Y el segundo caso es 21 CR 0067441Y y este es de la fecha del 20 de noviembre del 2021.
You were accused of driving under the influence of alcohol less safe and driving while license suspended or revoked.
Y se le acusa por manejar bajo la influencia menos seguro y por manejar con una licencia ya sea suspendida o revocada.
This is going to be is there a negotiated plea hearing, Ms. Vigiletti?
Judge, we're actually requesting that this case gets transferred back to Judge Edie's courtroom. Mr. Vasquez Lara has been working with the public defender there, who's been working in coordination with his felony attorney, and they have a plan to resolve both cases, the open misdemeanors and felonies, in coordination with each other.
¿Y han llegado a algún acuerdo? No, en realidad, a su señoría, queremos nosotros transferir este caso a la corte de la juez Eric, donde él tiene un abogado de oficio, donde a la misma vez están trabajando en conjunto con sus delitos graves.
I am going to arraign the case. Would you like to file a waiver of arraignment or would you like me to arraign it?
Sure, I can file a waiver.
Ok, voy a entonces el caso hacerlo a leer la lectura formalmente o renuncia a la lectura formal. Sí, lo podemos renunciar ahorita.
Mr. Vasquez, your attorney is going to waive arraignment and enter a not guilty plea on your behalf in both cases.
Ok, señor Vázquez Lara, su abogada, ella está renunciando a que se haga la lectura formalmente y ella está haciendo una declaración de no culpable en los dos casos.
Your cases will be sent to Judge Fred Edie to be scheduled for trial.
Y su caso va a ser mandado a la corte del juez Fred Edie, donde va a ser fijado para juicio.
That concludes these cases.
Y esto concluye los casos. Gracias. Thank you, Your Honor.
Thank you,
I think
Ms.
this is,
Labonte.
I think this is it for me.
I am 99.3% sure that you are correct. So, do the attorneys need a Spanish interpreter for any of their cases?
Not that I know of, Judge.
All right. Ms. Hovanik, we really appreciate you taking the time out to do this. Appreciate it. Thank you.
Thank you, Your Honor. Bye-bye.
Bye-bye.
Can we do the probation revocation calendar?
All right. Deputy Milton, you have a question?
Is it possible I can do Brianna Marks?
Let me take up this pro revocation matter and then I will move to
Okay,
Brianna
and
Marks.
we come back to my 3.
Okay, thank you.
No, you're not gonna do 3 bills, so we're gonna break it down, because we got 4 from 4 North, okay?
Oh, my goodness. Okay, there's going to be a competition right here. All right, Ms. Strong, if we can mute Fulton ACDC. And is 3 South the probation revocation matter?
Courtroom 2 is
Courtroom 2, okay.
probation revocation, position number 12, Sanders.
Probation revocation number 12. All right. This is State versus Marquez Deontay Sanders. Mr. Sanders, my name is Judge Lal, and you've been advised of your right to remain silent, and your attorney is Mr. McLean. Mr. Sanders is presently located with counsel in courtroom 2. His case number is 20 CR 5512C, and his probation revocation case number is 24 PV 389. Ms. Allen, who is our probation officer, has been sworn. Mr. Sanders pled guilty on April 18th, 2023. And Ms. Allen, what are the reasons that the state's seeking a revocation?
The defendant failed to complete his domestic violence counseling. He failed to pay his probation supervision fees in amount of $120 and his Georgia Victim Compensation Fund fee of $27. He failed to report to probation on May 8th as well as May 16th of 2023. It is enough time for the defendant to complete the family violence program. Probation recommends that the defendant be allowed to continue on probation and enroll in domestic violence within 30 days.
All right. And how many days does he have left on probation? I'm sorry. I want to make sure at least it's over 150 days.
Okay, give me one.
Or at least over 24 weeks.
$225 days remaining on his case.
Plenty. Okay, thank you. Thank you, Ms. Allen. Mr. McLean, what saith the defense?
The FVIP is 5.5 months because it is, let's see, that would be 5 to 30.
24 weeks? That's about 6 months, isn't it?
It's close. It's close to 6 months, and he has how many days left?
Over 220 days.
I understand. Very good. I'm sorry, I misheard the number. Your Honor, he has no objection. He will get on that and do it.
All right. I will accept the state's recommendation. He is required to report to probation on Monday, bright and early, before 3 p.m. And for the first 3 months, he will report twice a month. He will enroll in a domestic violence program within 30 days. And it can be online or it can be in person, but he must enroll in that program within 30 days, which means by his 3rd visit with probation, he must confirm that he has enrolled in such a program and that he has started classes. No illegal drugs, no alcohol, and he'll be subject to random screens. He must report twice a month for the first 3 months, and as long as he's in compliance, then it will be reverted back to once a month.
Very good, Your Honor. Thank you.
And this will be recorded as a probation violation. Okay. Ms. Allen, have we addressed all the cases on the probation calendar?
We still have.
No, we have still quite a few.
All right. I'm sorry, I don't have a printout, so I'm just going by Odyssey. So just keep me in line on that.
We can go to
Okay,
14 and 15 on probation. revocation.
14 and 15. Grady Strozier.
Excuse me. Excuse me, Your Honor. Yes, I spoke with Mr. Strozier yesterday and he understands the recommendation.
Just give me 1 second, please. I just want to get something from my printer. Just 1 second.
She was trying to come to
All right, let's go ahead and proceed with Mr. Strozier. And I do apologize, Mr. McLean. You were saying about Mr. Strozier?
We did get a chance to talk yesterday. He's aware of the recommendation.
Okay. Mr. Grady Strozier's case is 23 CR 004850Y, and his probation revocation case number is 24 PV 384. With regards to this case, Mr. Strozier, you have a right to remain silent as advised, and your attorney is Mr. McLean. In this matter, he pled on August 15th, 2023. Ms. Allen, what is the reason for the revocation and what's the recommendation?
Your Honor, the defendant failed to complete the substance abuse evaluation as well as any recommendation of treatment. The defendant failed to complete the family violence intervention program. He has a probation fee balance of $120. He failed to pay the victim compensation fund fee. He has a balance of $27. And the probationer failed to report to court as directed on October the 25th, 2023. And Your Honor, I'm trying to find my recommendation that was sent over to the public defender's office before I stated, but if I'm not mistaken, I said continue on probation, but I just wanted to verify my notes.
That is correct.
Okay.
Mr. McLean?
Your Honor, he would like the court to follow that recommendation. He'd like to double down and get this done.
All right. I believe he has still more than 220 days. Would you be able to verify that, Mrs. Allen?
Yes, I can. He definitely has 282 days remaining on his case.
All right. Mr. Strozier, as you see, if you don't report to probation, they kind of tend to miss you, and then they issue these invitations called a probation warrant, and you end up back at jail. And then on your record, it's marked as a probation violation, which doesn't look good if another judge has to look at it. So I'm going to accept the recommendation, but I am going to require you to report to probation twice a month for the first 3 months. Your first report date is going to be Monday. Does he have any other holes, Mr. McLean?
I'm not aware of it, Your Honor, but
I didn't see any, so I just want to be sure.
apparently not.
All right. He is to report to probation on Monday before 3 p.m. at 132 Mitchell Street. He will complete the alcohol and drug evaluation within 30 days of being released, not from report date, from today. He must go to a healthcare provider like Grady Hospital or wherever he likes to go, as long as it's a qualified provider, and complete the alcohol and drug evaluation and submit himself to any treatment that's required. He's not to consume any illegal drugs and no alcohol while on probation, and he will be subject to random screens. If he fails a screen, he'll be back in jail. He must enroll in the domestic violence intervention program within 30 days of being released. So that means by his third probation visit, he must confirm that he's enrolled in the domestic violence program. He will report to probation twice a month for the first 3 months. If he's in compliance with probation, then his probation will revert back to once a month from the 4th month onwards. Failure to comply will result in another probation warrant, and this will be recorded as a violation. Thank you.
Your Honor.
Position number 21 on 3 South.
Oh my goodness, 3 South. Is there a way I can do one case at ACDC?
No.
Please, Your Honor, I need Destiny Escobar. If I can please do her.
Yes,
and,
we're ready. We're
I'll
ready.
be back.
Let's do Escobar.
Your Honor, we have.
Hi. I'm trying to get out of here. I'm not trying to be here any longer. I did my 12 months probation.
You need to be quiet.
Why am I still here?
You need to be quiet, or otherwise I'll reset it to next week. You need to be quiet.
All right.
Otherwise, I'm going to reset this to next week. All right. Mr. McLean, is this your client?
Yes, Your Honor, she is certainly willing to do the MHET. She wonders.
Okay. Which calendar is she on?
She's on the add-on. I believe
Okay.
she would be number probably
2 and 3, Your Honor.
2 and
Okay.
3.
Thank you.
She's 3 is the FTA and 2 is the main one.
All right, let's
Your
go
Honor.
ahead and proceed, please.
Right.
This is Destiny Esobu, case number 22 CR 5658J, accused of simple battery family violence from August 22nd, 2022. Ms. Esobu has also got, again, you interrupt, I'm going to see you in 7 days. Ms. Esobu has also got a bench warrant for failure to appear in court, and that case number is 24 FTA 000271. Ms. Esobu, as well as the other ladies who are seated behind her, please remember this is a criminal proceeding. You have a right to remain silent. Anything you say about your cases, your statements can and will be used against you in the treatment of your case. You have a right to an attorney. If you cannot afford one, an attorney will be appointed to represent you, and your attorney will speak for you on your behalf. All right, Mr. McLean, how would you like to move forward with Ms. Esobu's cases?
Your Honor, she's offering the carrot, so to speak, that if the court could grant her a signature bond while she prepares for trial, she'll go ahead and get the MHET done while on bond.
Ms. Falk, it looks like they're asking for a signature bond pending trial.
Your Honor, it appears that in this case, Ms. Esobu was given a $2,500 good bond. That was back in August of 2022 by Your Honor. No further violent contact with Julie Ross Hall, social worker visit, and stay compliant with prescribed medications. I don't believe any of that was done as part of the bond conditions that were set 2 years ago on this case. And then she did fail to appear in court, which is what led to her being here today. It looks like the rule nisi on that was entered February 29th of 2024. What I will say is, based on Ms. Esobu's history, it appears that she has, seeing 4 arrests here in Georgia, 1 for the 2022 simple battery family violence, 1 subsequent for theft by shoplifting, another subsequent case for criminal trespass. That was March of 2024. So that was about 12 days ago. And then this failure to appear, which was then placed on her. So I do have concerns, given that she was given a surety bond. It doesn't appear that she completed the conditions of that bond. She didn't appear for court,
fine.
and she has cases that are subsequent to her original case, which was her first cycle here in Georgia. So
Uh-huh.
for those reasons, the state objects to bond
All right.
or
Miss-
bond reduction.
Thank you. Miss Julie, if you'd like to just give me a test that I can hear you.
Yes, ma'am.
All right. Could you please raise your right hand? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Ma'am.
And what's your full name?
My name is Julie Ross.
And how do you know Miss Destiny Essabu?
Destiny is my daughter.
All right.
I'm her
And
adopted child.
all right. And Miss Julie Ross Hall, is that correct?
It's Julie Ross. I'm no longer Hall.
Okay. And Miss Ross, is this your biological child or otherwise?
Yes, this is my biological child. I wanted to drop the charges on her due to other things that I need to speak with you in private about. If I could go private and talk to you about her situation.
All right. I can only address that after I've addressed my other cases. I have quite a few cases that are waiting to do that.
Yes,
Have
ma'am.
you spoken to Defense Counsel and Ms. Falk about this?
No, I haven't spoken to anyone. Just they told me that Destiny would be with the mental health court instead of this court, and I'm more than Destiny has been missing for 7 months. We haven't known where she has been located, and we want her to return back home so that she can get the mental health that she needs. I'm more than willing to open my home back to Destiny with no further contact as far as violent contact, but she needs mental health treatment.
Okay, and that's something I definitely need to address. If you could please hold, and I will definitely be speaking with you later, but I just need to address another location before I can move on with this case.
And
Deputy, yes, Ms. Go ahead.
My apologies, Your Honor. Our victim advocates, specifically Miss Christy Claremont and Miss Gloria Maldonado, have spoken with Miss Ross on March 12th via email, March 18th via telephone call, and yesterday via telephone call. And so we're more than happy to speak with her again, but I just wanted to clarify that we actually have had robust contact with Miss Ross.
All right. Okay. Deputy Milton, I'm afraid we'll have to put a pin in Miss Essabu's case until I can get more information from Miss Ross.
Your Honor,
I've been here for,
is it
I did a
possible?
12 months probation. I did a mental health evaluation.
All right, Deputy Milton, we will address this shortly.
Can we go to 3 South?
Yes, we may. Who do you have there? Ms. Strong, we can stop video and ACDC while we are addressing the other matters. Thank you. 3 South, please unmute.
It's Blunt.
Position number 21.
Okay. And is that the one that have multiple cases there?
I'm not sure. I just only see position 21.
Okay. Deputy, did I go to the wrong spot? I'm so sorry. It's a lot of 21. Okay.
That's a non-negotiated plea, Your Honor. Clifford Neal.
Okay. Clifford Neal is case number 24 CR 1071C, accused of battery, family violence, and the second count of battery against a female who is pregnant. Incident date is February 2nd, 2024. And Mr. Neal, you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and representing you is Mr. McLean. This is going to be a negotiated plea. Mr. Neal, please raise your right hand.
Non-negotiated plea, Your Honor.
Oh, sorry, non-negotiable plea. Please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge? I can't hear.
Yes, ma'am.
Thank you. All right, so a non-negotiated plea means that I'm going to hear from the prosecution, and then I'm going to hear from your attorney, and I'm going to let you know which option I'm going to select before you decide to move forward with the plea. Ms. Falk?
Yes, Your Honor. The state's recommendation on this case is 12 months served, 120 days, credit for time served 15 days. That would be from March 6th to March 21st of 2024, balance probated. Family Violence Intervention Program, 40 hours of community service, no further contact with Sadie Williams, as well as stay away from 2514 West Point Avenue. That's in Atlanta, Georgia, as well as no firearms. Count 2 would merge with count 1. The state's recommendation is based on a couple of things. Just kind of going briefly into the defendant's history, the defendant has a total of, let me just go down this, 35 cycles. The defendant's history includes theft, forgery convictions, drug convictions. Just go a little further down, Your Honor. As well as simple battery, where he received 12 months confinement in 2003 in Cobb County Superior Court. That charge was reduced. He also has a entering auto where he received 5 years in Carroll County in 2004, another entering auto where he received 5 years consecutive in 2004, a guilty to possession with intent to distribute in 2009 in Fulton County. He has a probation violation back in 2000. It looks like the arrest was 2007. There's another one in 2008. Financial identity fraud in 2008, financial identity fraud again in 2008. Those were both convictions. Possession of a firearm by a convicted felon. That's a 2003 conviction out of Clayton County. Probation.
What has he been doing the last 10 years though?
His last conviction was a Carroll County Superior Court case in 2017, where he received 5 years confinement for hit and run, felony obstruction, financial transaction card fraud, entering auto. So that's what he's been doing for the last 5 years. He was in Telfair Correctional Institute. After getting out of Telfair, he has a 2018 conviction for identity fraud and financial transaction card fraud, which he got a 10-serve-4 sentence out of Gwinnett County Superior Court, and had a 2022 arrest for PI. I'm not sure what the that result was. A probation violation in 2022, an arrest for battery in that's our case in March of 2024. And so that is where he's been over the last 5 years, which would account for the fact that he had a gap in his history.
And that is the reason why the prosecution is seeking additional day of jail time?
That is correct, due to that extensive history. In this particular case, this happened February 2nd of 2024. Miss Williams was having a physical altercation with Mr. Neal. They were former roommates, had lived together for approximately 6 months. A verbal dispute began. They began tussling. He then grabbed her by the neck, slammed her into the semi-truck, and then while choking her, slammed her head into the semi-truck steps several times. She screamed at him. He did not let her go. At that point, she got up after about 5 minutes, walked across the train tracks, arrived at the Exxon and called police. Miss Williams told the officers this is not the first time the defendant has been physically abusive to her, but she never called the police previously to report the abuse. Officers did observe an open wound with fresh blood on her cheek and a swollen, busted lip. So that is the recommendation. She was also 2 months pregnant at the time of the offense.
Mr. McLean?
Your Honor, with the additional time, that would cause 45 extra days. He has a hold in Carroll County he's going to be going to that, Your Honor, it's likely that he'll spend 45 days in Carroll County. So
he's got a hold in Carroll County and he's got a hold in Fayette County. So after he served time here, he will be traveling to either Carroll or Fayette County, whichever picks him up first. He needs to resolve those matters and then report to probation.
So we understand.
You're asking for, sir?
With the purpose of the additional time would have him reflect upon everything in order to avoid this sort of thing in the future, Your Honor. And because he's going to be spending so much time traveling to those other two counties, we were thinking that he has time for reflection anyway. So he would like to ask the court to simply give him a break on the 45 and make that time served or something close to it.
Under the circumstances and the egregious nature of the allegations, the request is denied. Mr. Neal can either consider the state's recommendation, or he can definitely enter a plea of not guilty and have the case scheduled for trial. He is presently on a $10,000 bond. If he makes bond, he will then be able to be transported to either of the Fayette or Carroll County to address the outstanding matters there.
Right, we're financially unable to do that at this time.
All right. How would your client like to proceed?
Mr. Neal, do you need to talk with me some more in private? That would be good.
All right.
Yes, I do.
All right, this case is going to be reset to March 28th. This reset will not prejudice the recommendation of the jail time. Thank you.
Keep going.
Okay,
Information revocation calendar.
3 South, are we?
We got position number 29, Mr. Tyson, if you want.
Okay.
No. Your Honor, can we go to the probation revocation calendar? We only
Okay.
have one
I'm
more.
so sorry, Deputy. Your voice is much softer because you're caught on the South and you're being drowned out by 3 South. 3 South, I'll be right with you. Courtroom 2?
Position number 3.
Okay. So Mr. McLean has dominion over the microphone, so,
Yeah, he's stolen the microphone.
yeah, okay.
Need more microphone.
Need more microphones, that's true. And chairs, okay. And this is the probation revocation calendar.
Position number 3.
Sorry. Okay. This is State versus Desmond Feltz. Mr. Feltz, my name is Judge Lal, and you've been advised of your right to remain silent, and your attorney is going to be Mr. McLean, Mr. Haddad, or
Judge, it's,
Mr. Haddad?
yeah, no, it's not. He has private counsel, Jonathan Melnick, Judge, represents him.
I can definitely say Mr. Melnick has not announced present.
Yeah.
So, Mr. Feltz, I'm going to have to reset your case to next Tuesday for Jonathan Melnick, for your attorney to appear to address your revocation case. All right, next case, courtroom 2.
Number 1 on the add-on calendar. For state officer.
Number 1.
On the add-on. Dawson.
I thought we did that one already. Mario Dawson?
You did?
You didn't tell me if I got my plea.
I'm sorry, you have to refresh my memory, Mr. McLean?
I believe we had finished on that. I could be mistaken, but he had the 40 hours of community service, the 8 hours of anger management, and
No contact with Abraham Lee and stay away from 535 Lee Street.
right.
Did we complete his plea hearing, or did he, oh, he wanted time to talk with you?
He wanted time for me to explain further, and we did discuss that, and we explained further, and I think we're fine.
Okay.
Okay.
I'm sorry, Your Honor, what position is this?
Position 1 on the add-on calendar, State versus Mario Dawson. I don't believe he took a plea. I think he wanted to speak with his attorney.
No, we did not complete the plea.
Oh,
Okay.
sorry, I was mistaken. I thought we had got through it, but there we go.
All right. So as we were discussing, Mr. Mario Dawson, we had gone through the whole colloquy about the plea, and the state, I believe you had recommended 12 months probation to serve 100 days, credit for time served 24 days. He has 24 more days to serve at the Fulton County Jail, after which he'll be placed on probation to do community service, 8 anger management classes, no contact, and stay away from the Texaco gas station, correct?
That is correct, Your Honor.
Okay. And Mr. McLean, do you stipulate to the factual basis, venue, and ID?
Right, Your Honor, we had noted that that was against advice of counsel, and we do so stipulate for the purpose of the plea.
All right. Mr. Dawson, have you consumed any medicine or alcohol?
No,
And have you understood the proceedings now?
yes,
Are you satisfied with your attorney?
yes,
And are you willing to plead guilty instead of going to trial?
yes,
Even if this decision is against the advice of your counsel?
yes,
If you decide to plead guilty to this charge, you would have to be placed on probation. Are you willing to do that?
yes,
And you will also have to be willing to give up your right to a trial.
yes,
You will not be able to go back to court, have the assistance of counsel to confront your accuser, challenge the evidence brought against you, and have the state carry its burden to prove the charge against you beyond a reasonable doubt. Are you prepared to give up these rights?
yes,
How do you plead to one count of simple battery from February 26, 2024?
yes,
Your sentence is 12 months to serve 100 days, credit for time served 24 days. You have about 24 or 25 more days to serve at the Fulton County Jail. Once you've completed your time, you would have to report to probation on the first available business day, which will be a Monday or a Tuesday or a Thursday.
all right, Your Honor, so that means I get out next month on the 14th?
I don't know. I'm assuming you have, today's the 21st, so 1, 2. It will hang on, it's 24 days, so it's 14.
You basically had 26 to today's date and then subtract 31.
It looks it's either going to be April 15th or the 16th.
All right, all right,
And then if you are released on the 16th, you must report to probation on Thursday, April 18th, before 3 p.m.
okay,
That same week that you are released, you must report to probation.
all right,
Once you're on probation, you will complete 40 hours of voluntary community service. You must begin by completing at least 5 hours in the first month and then 5 hours thereafter. You must enroll in an anger management program within 60 days of being released. And after that, you must complete the 8 weekly classes with no breaks in between. You must report to probation every month. At all times, you have to have no contact with Abraham Lee, and you're to stay 200 yards away. That's the length of 2 football fields from the Texaco gas station at 535 Lee Street in Atlanta, Georgia. You're not to return to that gas station at all.
all right.
Thank you. Next case.
Number 29.
Who was saying that? Was it 3 South or courtroom 2?
3 South, position number 29, Tyson.
Michael Maurice Tyson is case number 24CR949G. Mr. Tyson, my name is Judge Lal. You have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and representing you is Ms. Vigiletti. Mr. Tyson is accused of battery, family violence from February 28, 2024. Ms. Vigiletti, I'm so sorry. Let me see, 28, and that's going to be, okay. What would you like to do?
Yes, Judge, Mr. Tyson would like to enter a not guilty plea this morning, and we would like to be heard on bond.
Okay. Will you be filing a waiver of arraignment, or shall I arraign the case?
I can file a waiver.
Okay. Mr. Tyson, your attorney is going to waive the arraignment and enter a not guilty plea on your behalf. Presently, you did receive a bond, and I don't know why I can't pull up his case. I do apologize here. Let's see if we can try it again. Come on.
Your Honor, I am having the same issue. It doesn't appear that the case has been connected to a clerk number. There is a clerk number, but I think this occurred during Cybergeddon and it hasn't actually been connected up.
Okay, so what I do have on the battery family violence incident of February 28th, he's got a surety bond of $2,500.
Yes.
And he's also got a parole hold.
That is correct, Your Honor. It looks like the surety bond was ordered by Judge Mincy.
Okay. And I have private counsel who's just shown up on Zoom.
If you're speaking about Mr. Ellen, he's actually here to speak on behalf of Mr. Tyson's character, not as an attorney, but as a character witness this morning.
All right. Okay, let's first move forward with your bond request. Yes, Ms. Vigiletti.
Yes, Judge. You know, typically I would look at a $2,500 surety bond on a battery family violence charge and think that was, you know, pretty reasonable. This is a very special circumstance. After speaking with Mr. Tyson and just other members of the community, I've come to realize that Mr. Tyson's role in the community is so important, such that it is a disservice to our community to keep him in pretrial detention. Of course, I know this court considers Mr. Tyson's prior record, as well as his character and residence in the community. Mr. Tyson did serve a significant time in prison on drug charges many years ago. He was released from prison in 2019. He was at a low, he was homeless, he knew he had to change his life. He ended up staying at the Atlanta Mission. While he was at the Atlanta Mission, he really fell in love with the social services for which he was a client. He went back to college and he started asking the people around him, how do I do this work? How do I become a social service advocate? From there, he went to work for a needs clinic. They do HIV outreach. Within 2 months, he was promoted to outreach coordinator. He was hosting monthly health fairs in the community. And he has just had such a passion for helping other people ever since. When he was arrested on this charge, he was working for Zaban. It's a homeless shelter in Atlanta that specifically works with couples. Mr. Ellen is actually the executive director at Zaban Parodies right now. And Mr. Tyson was doing case management. He had recently placed 22 of his 39 previously homeless clients into long-term housing. Mr. Tyson's work is such an immediate need in our community that Zaban regrettably couldn't hold his job, but nevertheless, Mr. Ellen is still here to speak on the critical role that Mr. Tyson plays in the community, if you'd like to hear from him directly.
All right, thank you. Mr. Mellon? Yes,
Your
sir.
Honor, hi. Yes, it's Marty Ellen.
Yes,
and
sir.
I am, good morning, good afternoon. I am the executive director on interim basis at the Zaban Parodies Center. Part of what we do is not only to shelter people who are homeless, feed them, clothe them, but we also spend a fair amount of our time and our energy going out into the community to let people know about the services that are available. Mike Tyson joined our staff and was immediately one of the best outreach counselors we had, meaning he went under the bridges, he went into the encampments, he went with information, and he went with food, and he encouraged people to come live inside. He was one of the single best people I've ever worked with in terms of outreach. Then he came back to the office and worked on the administration of those cases and the other things that we do at the center to promote life skills so that when people leave the center, they can stand on their own. I can't comment on the allegations against him, but I can tell you that while at the center, he carried himself with dignity. He worked hard. His work ethic was outstanding. He was very effective, perhaps because of his life experience or because of his good communication skills. The man knows how to reach people in the community who otherwise feel that they have no voice. And my hope is that he will be able to continue his work on behalf of the people who are housing insecure or addicted, or the other things that Mike knows how to address. Happy to answer any questions, Your Honor, if there are any.
So Alan, you understand that even if I amend his bond, he still has a parole hold and he has other matters to address.
I do, Your Honor. I can
Okay.
only speak to the fact that I believe strongly in his ability to make a difference to lift this community.
All right. Thank you, sir. Appreciate it.
Judge,
Thank you,
if I
ma'am.
may speak to his parole hold,
Yes.
the parole violation, his parole is set to be up in August. He tells me the parole violation is due to this arrest, and he has already had dozens of people in the community send character letters. He is ready for that hearing. He is very hopeful and confident that that will go well for him.
All right. Thank you. Ms. Falk?
Yes, Your Honor. This incident happened back on February 27th at 1474 Mosley Place. It involves Miss Takoya Riley. She was in the house and they were laying on the bed. The defendant noticed her texting other individuals who were men.
Yeah, I've already read the warrant.
Right.
Do you
So-
have any other concerns?
Yes, the state's biggest concern actually is the fact that this defendant was not just sentenced for a drug case for which he was just released into 2022. He was sentenced on an aggravated assault case where he received a 10-serve-1 sentence, and the conditions of that sentence were he have no further contact with Demetria Tyson and that he do a domestic violence intervention program. So there's already a history here, Your Honor, not only of violence, but of violence towards women, given the fact that the person who he committed the previous offense against, there was a domestic violence intervention program included, and now he has this case. The only reason the state did not upgrade this as a family violence battery felony is because that aggravated assault was not a family violence aggravated assault, even though he was sentenced to domestic violence intervention program as a part of that sentence. And for that reason, the state asked that the bond remain as set, $2,500 for a person who just got out of prison 2 years ago for an aggravated assault is very low.
Okay. All right. On the simple battery family violence, it's going to be amended to a $5,000 signature bond through pretrial services. Mr. Tyson will report to pretrial once he is released on his parole hold. He will report once a month. He's to have no contact with, I want to make sure I got a name right, Takoya Riley, and he cannot return to the same location, 1474 Mosley Place in Southwest Atlanta. He may return one time only with a police officer to either verify that Miss Riley is no longer living there, then he can return to location, or he has to stay away from that location and then update the court with his new mailing address within 30 days of being released from the parole hold. He will report to pretrial once a month, every month. He will be subject to random screens for illegal drugs and or alcohol. And based on the allegations as well as his record, he's not allowed to own any weapons or firearms. Make sure that he reports to court at all times. Mr. Tyson, unfortunately, you are one of our classic cases where even though there are definitive steps towards rehabilitation and being a valuable member of society, sometimes your past comes back to bite you very, very harshly. And these are the steps you have to take in order to continue with your progress to recovery and being a valuable member of the society. Thank you.
Judge,
Your Honor, if we could sound for Mr. Takoya Riley, I believe she
I'm
is here
sorry.
in the court.
Miss, good. Thank you. Miss Riley, you're present. You didn't indicate you were here. Miss Riley, if you want to say something, this is the time to say it before I make this a final decision.
Yes, hello. I'm trying to, how do I put my video on? Hold on.
All right. Miss Strong, if you can give her a prompt to start video. All right. Miss Riley, my name is Judge Lal. Are you driving?
No, I'm parked, but I'm in the passenger side.
Okay, please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes.
All right. Ms. Riley, I have provided Mr. Tyson a proposed signature bond where he'll have to report to pretrial he'll be required to stay away from you and stay away from the location where you live. Do you still occupy the Mosley Place location?
Yes.
Okay, so he's not allowed to live there. He can only go back there one time with a police officer to retrieve his personal belongings. After that, he'll be required to stay away from you and not have any contact with you whatsoever. Do you have any comment at this time?
Well, I'm not requesting no contact. Like, we have to stay in contact because I'm currently 6 months pregnant. So we're expecting in July. And the house is his house. So I live with him and he was the head of household. So if he leaves, that means I leave. And like I said, once with the baby, you know, coming soon, like that is our place of living. So I'm not, him being around me, that's fine. Like, I don't fear him. He's not a violent person. We got into a disagreement. That was that. So, and him coming back to him having to stay away from his own house, I do disagree with that.
All right. I'm still going to require the no contact and that he does not. If you wish to vacate the Mosley Place and find a separate housing for yourself, then he can return to the Mosley Place. But you and he cannot live together. If are you presently married to him?
No, ma'am.
Okay. So if he seeks to have visitation and custody of the child that you share with him, he would need to file a legitimation action and get a court order for respect to that. Now, after he has resolved his parole hold, if Ms. Vigiletti, if you all would like to schedule a hearing in order to amend the no contact to no violent contact, I'm sure the court will entertain it at that time. But presently, under the circumstances, it has to be stay away and no contact. Thank you.
Thank you, Judge.
All right, that concludes Mr. Tyson's case, and this case is further notice for trial. Courtroom 2, do you have any other cases there?
We do not.
All right, 3 South.
I got Mr. Evans. Have a seat, sir. Mr. Evans, his position number.
I've got it, position 10. Thank you. All right, this is State versus Evans, Troy Evans, 24 CR 1092G. Mr. Evans is accused of willful obstruction of an officer, criminal trespass, and committing certain acts at a bus, rail, or station which are prohibited. Mr. Evans, you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and your counsel is not in courtroom 2. Mr. Haddad? Oh, there you are. I'm so sorry. Okay. I'm so sorry. It's the shifting of the chairs. I wish we had a wider panoramic vision of the courtroom. Okay. Mr. Haddad will be your counsel at the present time. This is going to be a negotiated plea. So if we can unmute 3 South, and Mr. Evans, please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge? Yes. Thank you. Mr. Graham?
Yes, thank you, Your Honor. The state's recommendation in this case, count 1, willful obstruction, 12 months, served 30 days. Credit for time served, 15 days from the period of March 7, 2024 until today. Balance probated, $300 fine. Count 2, 12 months concurrent with count 1. 12 months probation concurrent with count 1. Stay away from MARTA in compliance with any and all suspensions. And count 3, 12 months concurrent with count 1.
Thank you. Mr. Haddad, does your client stipulate to all the factual basis, venue, and ID?
We do for purposes of the plea, Judge.
Thank you. Mr. Evans, have you consumed any medicine or alcohol?
No.
Are you satisfied with your attorney?
Yes.
Is anyone forcing you to plead guilty today?
No.
And has it been explained to you that if you plead today, you would have to give up your right to a trial, to go back to court and confront your accuser, challenge the evidence brought against you, and have the state carry its burden to prove the charges against you beyond a reasonable doubt? Are you prepared to give up these rights?
If I lose today,
Are you prepared to give up your rights to a trial, to confront the accuser? I'm sorry, what was that response?
yes,
If you, are you entering this plea freely, willingly, and knowingly?
yes,
How do you plead to 1 count of willful obstruction of a law enforcement officer, criminal trespass at MARTA, and committing certain acts at a bus, rail, or station which are prohibited?
I was wondering if you could tell me the definition of willful obstruction of an officer?
In a misdemeanor count, that means not obeying their commands.
Oh, okay. Your
How do you
question,
plead?
not guilty.
Okay. Mr. Haddad, this is going to be a not guilty plea. Mr. Evans, I'll accept your not guilty plea. The case will then be scheduled for trial. At the time of the trial, the prosecution will have the complete burden to prove the charges against you beyond a reasonable doubt. If the prosecution does carry its burden and overcome your legal presumption of innocence, you may be convicted of 1 or more of these offenses and face a penalty of up to a year in prison and or up to $1,000 fine. Please unmute 3 South. Given this information, would you still like to proceed with your not guilty plea?
Yes.
All right. This case is further notice for trial. Thank you.
Thank you, Judge.
Okay, 3 South is concluded. Courtroom 2 is concluded. ACDC?
I've got Brianna Marks.
Deputy Milton, I will take the other 2 cases, not Miss Fields, because we have to still have to do a breakup.
I have Ms.
What's your name, please?
Brianna Marks.
Kenya Boyington Grigsby.
Oh, I'm sorry, that's not her.
Janietta Boynton, okay?
No, Kenya, just Kenya.
What's your last name?
Boyington Grigsby.
Grigsby.
She goes by this kid.
That's Attorney Bartel's client.
Oh, that's my.
I don't see on the main calendar.
Yeah, she's on the competency calendar, Your Honor.
Okay, we'll have to do this one in a breakout.
Okay, well, Your Honor, if I could just let the court know, Ms. Falk and I have already agreed upon a negotiated plea agreement, and I've spoken with Ms. Boynton Grigsby and filled out that paperwork, and I just forwarded it to Ms. Champion and to Ms. Falk. So
Okay.
I'm ready to go forward with that whenever you want.
All right, I can do it right now then if you want.
Okay.
Are you willing to do it in open court?
Yes, ma'am, I am.
Okay.
I believe she is certainly able to proceed.
Okay. Miss Kenya Lachelle Boynton Grigsby is case number 24CR 974G. Ms. Boynton Grigsby charges were reckless conduct and criminal trespass from March 1st, 2024. Ms. Grigsby, you have a right to remain silent about the facts of the case. Anything you choose to say about the circumstances of the case, your statements can and will be used against you. You have a right to an attorney, and your counsel is Mr. Paul Bartel. May I place you under oath for purposes of the plea? Ms. Boynton Grigsby, do you solemnly swear and affirm
Yes.
the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Thank you.
Yes, Your Honor.
Mr. Graham, what is the recommendation for this lady?
And my apologies, Your Honor. Deputy Falk was handling this case and she had to step away for just a moment. I was looking through, but I don't actually have a copy of the recommendation for this particular case. Can we?
She's back.
Oh, okay.
I think there she is. Okay.
Hi.
I'm sorry, Paul. We are addressing position number 1 on the competency calendar.
Ah, okay.
Council has agreed to do this in open court.
Oh, yes.
Yes, what's the recommendation, please?
The recommendation on this case, Your Honor, is, let me just pull up the recommendation I sent Mr. Bartels. It is going to be 12 months on count 1, probation, serve 40 days, credit for time served 20 days, balance suspended. We would ask that she comply with any restrictions from MARTA. And then on count 2, we are recommending that count 2 merge with count 1.
And that is our agreement, Judge. I would just clarify, it's a suspended sentence, not probation, correct?
Right, that is
Understood.
correct.
Yes.
Okay.
All right. And do you stipulate to the factual basis venue and ID, Mr. Bartel?
We do for the purposes of plea, Your Honor, and she does understand that whatever active suspensions are present, that she would have to abide by that.
All right. Ms. Grigsby, have you consumed any medicine or alcohol recently?
No, ma'am.
And have you understood everything that's been going on, including what your attorney has discussed with you?
Yes, yes, Your Honor.
Are you satisfied with his legal services?
Yes, Your Honor.
And if you decide to plead guilty today, you would have to give up your right to go back to court and have a trial in front of a judge or a jury. You won't be able to be seated with your attorney so that you can confront your accuser, see the evidence that's brought before you, present any defenses or arguments if you have any, and have the state carry its burden to prove the charge against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, Your Honor.
How do you plead to 1 count of reckless conduct?
Guilty.
Your sentence is 12 months to serve 40 days, credit for time served 20 days, balance suspended. Your jail time is concluded, the case is closed. You cannot return to MARTA, any of the MARTA property, if there are any active suspensions against you. You would need to contact a MARTA officer to check and see if there are any active suspensions and when do they end. If there are none, then you can continue to use MARTA services legally. Do you understand?
Yes, Your Honor.
All right. That concludes your case. Thank you.
Thank you, Judge. And thanks, Ms. Falk.
All right. Next case.
This is Ms. Mark.
And I'm sorry, could you give me your name again, please?
Brianna Marks.
Okay. And I believe she was on the add-on calendar.
Judge, that's Mike's case. I don't know.
All right.
Let me find it.
All right, sir.
Judge, while we're waiting, I could maybe make an announcement on Twinetta Ponder.
To which calendar?
So she is on the SAP calendar as positions 22 and 23. She
Okay.
is also on the probation calendar mistakenly as positions 8, 9, 10, and 11.
All right. And what's the announcement?
So the probation matter, I did send an email about this, Ms. Allen. I just want to make sure you saw that.
Yeah.
The probation revocation is actually her twin sister. So that should not be open against Twinetta Ponder. It should be open against Janetta Ponder. They are 2 different people. I was able to confirm yesterday.
Okay. So the SAP calendar, the cases are against the right person, correct?
The SAP cases are against the right person. She does have a bond on those cases, so she is going to be released today, so that those should be reset for trial.
Mrs. Allen, with the probation revocation matter, are those against Twinetta Ponder or Janelle Ponder?
Janetta.
Janetta.
Ponder.
Janetta Ponder.
Yes.
Okay. So I guess we'll need to correct that with the jail records to make sure that the booking information and the identity information are correct.
Yes, I spoke with them last night. They've made the correction.
Okay, that's good. So the only thing holding her are these. All right. Mr. McLean, are we ready with Brianna Marks?
Yes, Your Honor, the state and I were discussing whether or not the state could maybe consent to a signature.
Ms. Falk?
I was muted. On Miss Marks' case, can I get the current bond on that one? Sorry, I'm just jumping around a bit.
Brianna Marks, on position on the add-on calendar.
Let me just pull her up in our system.
The
really
bond is
quickly.
presently $7,500.
And that's a surety bond.
Correct. She
The
was
state-
booked in on January 17th, 2024. Yeah.
And my understanding is she was loaned out to Gwinnett County, and is back. Is the Gwinnett County case concluded, PD McLean?
I believe she was there. What was the purpose, Ms. Marks, of your being in Gwinnett?
And she's on mute.
Unmute.
Deputy Milton, yeah.
My purpose, I requested juvenile court in regards to my 1-year-old with Robert Ghazali, who was my original attorney. It was something that I requested to check on my daughter.
Okay. So, that's over with, right?
Yes, yes, sir.
And she does have a place to stay. She has her own apartment.
Your Honor, the state is agreeable based on the information provided to me by PD McLean with converting this to a $5,000 signature bond through pretrial services, that she have no further contact with Dianesh Burns, and that she stay away from 2718 High Tide Drive in Atlanta, Georgia.
Very good.
Okay. Miss Brianna Marks.
Yes, Your Honor.
I'm not certain what's going on, but apparently someone doesn't want you around and doesn't want you anywhere near them. You've been at the Fulton County Jail since January 17th. And I'm not sure if you've enjoyed being there. But if I grant you the signature bond, and if you violate the conditions of the bond, you'll be right back where you're sitting right now.
Yes, Your Honor.
It's that simple.
Understood.
On the stalking charge, your bond is set at $5,000. It's a signature bond through pretrial services. I'm going to keep you busy and have you report to pretrial twice a month. That's going to be level 2. You are to stay 200 yards away from Dianesh Burns. I think you've heard that very often. Do you understand?
Yes, Your Honor.
Do you understand what it means to stay away from Dianesh Burns?
Yes, Your Honor.
Can you tell me?
No contact, no social media contact, no physical appearance, even if it's in regards to the kids. No coming to the house, no reaching out to family members, like it said on the paper with Robert Ghazali, or any friends, I think it's what it said. So.
All right. You have to stay 200 yards away from her, which is the length of 2 football fields.
Yes, Your Honor.
You cannot call her on the phone, on a computer, and you cannot discuss on social media. You cannot contact a third party. I think that pretty much covers your understanding of it as well.
Yes, Your Honor.
You cannot return to 2718 High Tide Drive in Atlanta, Georgia.
Yes,
Now
Your Honor.
explain to me, who are these kids?
She's my daughter's stepmother.
She's your daughter's stepmother.
Yes, Your Honor. We share
right.
the father.
Okay. Does she have present guardianship over the children?
My mother has guardianship, temporary guardianship over Faith Marks right now. So in conclude, it's
You are to stay away from your daughter as well.
Stay away from my daughter?
Yes, ma'am. As long as she's a temporary guardian, you
No,
can.
Denise is not a temporary. Denise is not temporary guardian. Denise is my daughter's stepmother. My mother has guardianship over my child right now instead of her.
Like, that's not part of the case, right?
Yeah.
Oh, I'm sorry. So hang on. the Miss Marks is not supposed to be, when I'm able to show. Is your daughter live with Miss Dionysia Burns?
No, I was looking for her father, which has been missing, in regards to the
Okay.
situation. So she doesn't live with her.
All right. So as long as your daughter does not live with, that's what I thought. Does Dionysia Burns have custody over your daughter?
No, she doesn't have custody.
Okay,
She's just
all
my
right.
daughter's stepmother, but I do understand the stay away. Is it possible for me to get a copy of all of the information so I can proceed to follow the directions?
All right. You're going to get a copy of it through Mr. McLean, and you're also going to get a copy of it from your pretrial officer because you'll be reporting twice a month. So just to clarify, you're to stay away from Miss Dionysia Burns, stay away from High Tide Drive, and have no contact with her whatsoever. If somebody you know happens to be with Miss Burns and you need to go see that person, that's a definite no-no.
Yes, Your Honor.
All right. You report twice a month. You cannot afford to get arrested again, and you cannot violate any of the other conditions of the bond. Otherwise, you're back in jail.
Yes, Your Honor.
All right. That concludes this. Mr. McLean, will you be able to submit a proposed order?
Yes, Your Honor, we'll do that.
Okay. Thank you. Level 2, please indicate that through pretrial.
Thank you.
All right.
Position number 15, Mr. Horn.
Okay, we'll be addressing Mr. Horn. Yes, Deputy Milton?
Okay, I got to leave out of Zoom to go to felony, and then I will come back.
Okay, okay, that'll be fine.
Okay, thank you.
Okay, 3 South. Who do you have again?
Horn, number 15.
Thank you. Christopher Horn is charged with simple battery from July 28, 2023. And his case number is 24 CR 1104E. Mr. Horn, you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and Mr. Michael McLean will be your counsel. And Mr. McLean, are we doing a negotiated plea? Okay. Mr. Horn, if you please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Thank you. Mr. Graham, what's the recommendation?
Yes, Your Honor, the state's recommendation is 12 months to serve 28 days, credit for time served 14 days. It's a period from March 8th, 2024 until today. Balance probated, 40 hours of community service. No further contact with Terrence Phelps. Stay away from 100 Foxlair Drive, 8-week anger management. And if we can sound for Mr. Terrence Phelps, Your Honor, according to Marcy's law, and we'll ask the defense to stipulate to factual basis, venue, and identification.
For the purpose of the plea, we certainly do so stipulate.
Terrence Phelps, if you are present and like to contribute, you need to start your video and unmute. All right. Mr. Horn, have you consumed any medicine or alcohol recently? You need to speak up a little louder. I can't hear you.
No, ma'am.
Thank you. And are you satisfied with your attorney?
Yes, ma'am.
Have you understood the proceedings so far?
Yes, ma'am.
And are you entering this plea freely, willingly, and knowingly?
Not really.
All right. And do you understand that if you don't want to enter this plea freely, willingly, and knowingly, then I will reset this case for trial. And I'll definitely let you exercise your constitutional right to have a trial before a judge or a jury, where the prosecution would have the complete burden to prove the charge against you beyond a reasonable doubt. So I think we're going to go ahead and arraign the case then. Mr. McLean?
Your Honor, I can file a waiver if that's okay with Mr. Horn. Waive the arraignment.
All right, Mr. Horn, your attorney is going to file a document which is called a waiver of arraignment and enter your not guilty plea for you. Once that document is received, your case is arraigned and it will be scheduled for trial. At the time of the trial, you do have a right, you are legally presumed innocent of this charge, and you do have a right to have the state prove the charge against you beyond a reasonable doubt. If they are unable to reach that burden, you will be acquitted of that charge. Do you understand?
Yeah, ma'am.
And unfortunately, if the state does prove the charge against you, you could be convicted and face a penalty of up to $1,000 fine and or up to a year in jail. Thank you.
Position, probation 1 and 2, Mr. Brown.
Thank you.
Judge, John, on Mr. Brown, I've not been able to speak to him, but probation is recommending continuing him on probation. If the court is inclined on not following, then I'll need a breakout.
All right, let me first see. Mr. Terrence Brown, case numbers are 21 CR 0000140Y, and his probation violation case number is 24 PV 382. In the original case, Mr. Terrence Brown had entered a plea on April 4th, 2023. Excuse me, yeah, on April 4th, 2023. And so, Mr. Brown, you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and Mr. Jawan Haddad is your counsel who is in courtroom 2. Do you understand that there is a warrant to revoke your probation and have you serve out the rest of the sentence in jail?
No, I wasn't aware of that.
Okay. So if you're not aware of that, I'm just going to let probation officer Miss Allen tell me what is the basis they're seeking a warrant, and then I will let you have a chance to speak with your attorney. Miss Allen?
Your Honor, the defendant failed to pay his probation supervision fees. The defendant failed to report to probation July the 17th, 2023, July the 31st, 2023, and August the 15th of 2023. The probationer also failed to complete 100 community service hours. And at this time, probation recommends this defendant be allowed to continue on probation.
All right.
Judge, on behalf of Mr. Brown, Mr. Brown, you understand that probation is recommending that you get reinstated. That's their recommendation. But you do have to report to probation. You have to do what you're asked to do, which is primarily the fine and the community service. If you need to speak to me, we can go in a breakout room. Judge, I would just, in light of the charges and the recommendation, I would ask the court to follow the recommendation. If the court is hesitant or is not inclined, then I'd be happy to do a breakout room, Judge, to get a little bit more information from Mr. Brown.
Miss Allen, was he required to have reporting probation?
Yes, he was. He missed his probation appointments. I'm reviewing the notes right now. It looks like he reported to our office at least 3 times. And so at some point he stopped reporting, and it looks like he was told to report back on July the 17th, and he failed to report. And so that's when he failed to report on those dates. And we sent a letter to his home address.
Mr. Brown, would you like an opportunity to speak with the attorney?
I guess, but it's not I want to like conceal, but I was incarcerated for 5 months, and that what kind of led to me not reporting and stuff like that.
Did you tell your attorney or probation that you were in jail?
No, I didn't get a chance to. And as far
And
as
after
the,
you came out of jail, did you go back to probation?
no, I haven't been released yet. I've been
I'm
locked
sorry?
up. I haven't been released yet.
Okay.
I've been
I
locked up
think
since
I think you need to talk to your attorney at this rate.
Good. All right, that's
All
fine.
right. We can put courtroom 2 and 3 south in a breakout room.
Thank
And
you.
strong? All right. I have a bench warrant matter, actually 2 of them. Ms. Strong, if you'd like to put court, thank you. Okay. I have State versus Eric Castillo.
Good morning, Your Honor.
All right. Ms. Warlick, are you counsel for Mr. Castillo?
I did not receive notice, and I think my client got his notice after the court date had passed. So
Hang
we're
on,
just
I
asking.
don't, just a minute, please. I don't see your client. He's unmuted. Okay. Mr. Castillo, you need to go find a spot to sit down and not walk around. Quickly. All right. This is position 22 CR 006390G. State versus Eric David Castillo. Mr. Castillo, you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and your counsel is Ms. Danielle Warwick. Is it Warwick or Warlick?
Warlick.
Warlick, okay. It appears that Mr. Castillo was accused of battery, family violence. The accusation was filed on September 21st, 2022. All right, and I'm trying to see when was this bench warrant issued? Is this the case in which he's got a bench warrant?
So apparently the court date was on March 7th. When I went down to inquire about the bench warrant status, they said it hadn't been processed yet, but there was a motion made. So we were just trying to get ahead of it, assuming that the bench warrant was coming down to get it lifted.
Well, this is called a preemptive motion for set aside a possible bench warrant. I'm not sure how to deal with that, Ms. Falk. Any comment?
Your Honor, I would say this motion is premature. If there hasn't been a bench warrant filed, what exactly are we lifting?
I don't see any. I wasn't the judge who issued the bench warrant. This was Judge Mather. So
correct, and they wouldn't just put us back on the calendar. So that's how we ended up here.
And Your Honor, I can reach out to Judge Mather's courtroom and the litigation manager and solicitor general in that courtroom and ask that case be placed back onto Judge Mather's calendar to address before Judge Mather.
Okay. All right. If there is a bench warrant, then definitely that will be put on the calendar by Judge Mather, but I haven't got hide or clue about an outstanding bench warrant. All right. Thank you.
All right, Your Honor.
Feel free to go.
Thank you.
And in Your Honor, before you leave, Ms. Warlick, can you put your email address in the chat so I can CC you on this email I'm about to send?
Got it. I'm sending it directly to you.
Okay.
Okay. The next case I have for a possible bench warrant is State versus Michelle Burnett. Michelle Burnett.
Hey, I am here.
And Ms. Burnett, you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney. And who is your attorney?
Judge, Rose Woodbury is Ms. Burnett's attorney, but I've spoken with Ms. Woodbury about this case, so I'm prepared to help today if I can.
All right. It looks like there was a plea and arraignment calendar before Judge Richardson on February 20th. looks like it's going to be further notice for trial and she's for bench trial. So do you know if a bench warrant was issued?
I do not, I'm not certain if a bench warrant was issued.
Your Honor, it looks like pretrial issued a bench warrant due to non-compliance.
I see. And has the bench warrant been signed?
I am not sure. It looks like, let's see.
Excuse me, Your Honor. Yes, it was signed by you back in August.
Okay. I don't see it filed, but if you can screen share a copy of that bench warrant, that'll be great. August.
Yes.
Ms. Champion, would you be able to screen share a copy of that bench warrant?
I'm not sure if I have the ability, but I have it pulled up.
Okay.
Give me one second. Let me see if I'm able to screen share it.
You just hit share screen at the bottom if you have rights. And there it is. Okay. All right, here it is, Ms. Vigiletti. Looks like there was a $3,000 surety bond set on the bench warrant where Ms. Burnett failed to report to pretrial or failed to comply with pretrial. All right, we can stop the screen share, please. All right. Yes, Ms. Vigiletti.
Yes, I'm reading notes from Rose on my phone, but my understanding is that Ms. Burnett did change her number and forgot to update pretrial. There was a little bit of additional confusion because she got a new pretrial officer and had some confusion about who to report to. That's why she missed her hearing date, but she did appear in court on February 20th. Ms. Woodbury actually wasn't present, but Ms. Burnett was. And so they have the correct contact info for her now. She's also here today. I don't think we're going to have any more issues going forward. It was just a contact information issue and all the correct contact info is on the record now today.
All right. Ms. Falk, any comment?
Just out of curiosity, did she ever report to pretrial or she was reporting and stopped?
I cannot recollect the pretrial affidavit, so Ms. Tyson would have to read it.
See. It looks like she completed orientation and then it looks like they tried to contact her 1, 2, 3 times. So on June 30th of 2023, July 5th, and then July 10th, they called, left voicemails on those 3 days. And they mailed her a letter. And they mailed her a letter on June 14th and no response. They received no response. And that's when they submitted the bench warrant.
So yes,
basically just orientation and then that was it.
Based upon that, the state would object to lifting the bench warrant. She hasn't even, I understand what Ms. Vigiletti is saying about her pretrial officer changing. It sounds like she never even met with her pretrial officer. She didn't make it past orientation.
All right.
Ms. Burnett, may I ask you, when you updated your phone number, did you also update your physical address?
Yeah. When I try to connect to the link to the things I have to see in the moment for some class, I connect for 20 minutes, but my phone number, everything, say my stepmom. I have the problem with my stepmom. Like I can't be around her in the
How
moment.
did you show up in Judge Richardson's courtroom?
Sorry?
Did you show up in Judge Richardson's courtroom?
I take like 5 minutes in the class and my phone is gone.
What language do you speak?
Spanish.
Okay. Do you understand what's going on?
A little bit, yeah. She explained me the other lady supposed to be here.
All right, looks like we need a translator for
Yeah.
Miss Burnett to understand why she may be going to jail.
Yes,
I asked for translate for somebody.
I'm so sorry, Judge, I did not receive that request. We're passing things through another attorney this morning.
All right. Miss Burnett, I'm going to set aside your bench warrant. Are you listening?
Yeah.
You did not report properly to pretrial.
Yes, because
I'm not interested in those reasons. Do you live in Pooler, Georgia?
not anymore.
Okay. Where is your new address?
150. I changed my new address to. I back to my home. My new address 550 River Club, Acworth, Georgia.
Acworth, Georgia?
Yeah.
You must come down and report to pretrial once a month in person. No phone, no email. In person.
Okay.
You must drive down to Fulton County Pretrial Services and report in person.
Okay.
Beginning Monday.
Okay.
All right?
Okay. Around one time?
And you must report every month until your case is over.
Okay, perfect. I don't have any problem.
Every month.
Okay.
You must drive down from Acworth and meet your pretrial officer.
Okay.
In person. Tomorrow you will come down to the Fulton County Courthouse. Write down this address.
What? Okay.
160 Pryor Street, Atlanta, Georgia.
160.
60.
Okay.
Pryor, Pryor Street, Atlanta, Georgia.
Sorry, you can in the comments on something because I don't understand.
Miss Strong, can you give her the address, please, for the clerk's office? Suite.
I'm about to put it in the chat now, Judge.
All right, now check the chat.
Thank you.
You must come down to this office tomorrow and give us your new address in writing.
Okay.
If you need to bring someone to help translate, bring a friend who speaks English.
Okay.
If
Ms.
you
Burnett,
don't-
can you, I'm sorry, Your Honor, go ahead. Sorry.
If you don't do this, you will be in jail.
Okay.
That's the simplest English I know.
Okay.
Ms. Vigiletti, please submit an order setting aside the bench warrant and the requirements that she report to pretrial starting Monday in person and every month thereafter. The original conditions remain in place, no violent contact and so forth.
Okay, thanks, Judge.
And she needs to update her mailing address by 5 p.m. tomorrow in writing.
Okay, and I'll follow up.
All right, appreciate it. Thank you. You're free to go.
Sorry, Ms. Burnett, can you put your phone number in the chat too also?
Yeah, sure.
Okay, thank you.
Probation 1 and 2, Brown.
All right, Ms. Strong, you can mute Zoom user, Ms. Burnett. Okay, 3 South, we have probation 1 and 2.
Your Honor, thank you for the opportunity to speak to Mr. Brown. So Mr. Brown has been detained since October 18th of 2023. He was arrested for giving a false name. Then he was transported to Clayton County, had a probation violation. Then he was transported to Fulton County. So he's been in jail one jail or another since October 18th, Judge. He is 24 years of age, Judge. He runs his own business. Judge, I would ask, in light of the time that's left on probation and the fact that he did report, it appears, the first 3 months, and then he just, I'm not sure if that coincides with when he was arrested, Judge, or when he missed probation.
Let me find out. How much more time does he have on probation? Miss Allen?
Your Honor, he has 560 days remaining on his case.
All right. I'm going to mark this as a probation violation and continue him on probation. He's required to report as soon as he's resolved his current holds.
Thank you, Judge.
All right. And Mr. Brown, once you've resolved your current holds and you report to probation, you need to start on your community service hours with completing at least 10 hours per month. Thank you.
Thank you, Judge.
Number 16, Jackson.
Is that on probation too?
No, ma'am.
All right. Tawan Jackson is position number 16, accused of theft by taking from February 20th, 2024, case number 24 CR 1102H. Mr. Jackson, you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and representing you is Mr. Michael McLean. May I place you under oath for purposes of the plea? The other right hand. Your other right hand, yeah. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge? Please unmute and then we will hear you. Do you so swear?
Yes, Your Honor.
Thank you. Oh, nice, loud and clear. Okay, thank you. Mr. Graham?
Thank you, Your Honor. The state's recommendation on this case is 12 months served, 60 days. Credit for time served, 15 days. That's the period beginning March 7, 2024 until today. Balance probated, anti-theft course, restitution open for 30 days. No further contact with Alexander. It's Alexandre Kotdrski, Kotdrski. And then there's another open trespass case, 24 CR 001344. The state's recommendation is 12 months to serve 8 days, credit for time served 4 days. That's a period from January 6th through the 9th, 2024. Stay away from all MARTA and to run concurrently with the previous case.
All right, thank you. So he is addressing two open cases then, with the criminal trespass in 1344. Mr. McLean, do you stipulate to the factual basis, venue, and ID for both cases?
For each case, we do so stipulate for the purposes of these. And Mr. Jackson, you do understand about the stay away from MARTA part, right?
Yes, sir.
Okay.
All right, Mr. Jackson, have you consumed any medicine or alcohol recently? Have you consumed any medicine or alcohol?
No, Your Honor.
And have you understood the proceedings?
Yes, Your Honor.
Are you satisfied with your attorney?
Yes, Your Honor.
And are you entering a guilty plea to these two cases freely, willingly, and voluntarily?
Yes, Your Honor.
You decide to plead guilty to theft by taking and criminal trespass, you would have to give up your constitutional right to a trial for each case. You will not be able to have an attorney to go back to court, confront your accuser, challenge the evidence brought against you, present any arguments and defenses, and have the state carry its burden to prove the charges against you beyond a reasonable doubt. Are you prepared to give up your rights?
Yes, Your Honor.
How do you plead to one count of theft by taking in case ending in 1102H?
I would like to plead guilty, Your Honor.
How do you plead to one count of criminal trespass in case ending in 1344?
I would like to plead guilty, Your Honor.
On the theft by taking, your sentence is 12 months to serve 60 days. Credit for time served, 15 days. I believe you have 15 more days to serve at the Fulton County Jail. After you have served the additional time, you will be placed on probation. While on probation, you will complete an anti-theft class and have no contact with Alexandra Kotdrski. On the criminal trespass, your sentence is 12 months to serve 8 days, credit for time served 4 days. Your jail time for the trespass charge is concluded. Once you are released and reporting to probation, you shall stay away from all MARTA property while you are on probation. Please make sure that you report to probation within 48 hours of being released from the jail. Probation office is at 132 Mitchell Street in downtown Atlanta. Thank you.
Thank you, Your Honor.
Your Honor, this is ACDC. Is it possible we can go ahead and take you with, Ms. Destiny Escobar? If not, I will have to take her back.
Okay.
Come on up.
Ms. Strong, can you place Miss Julie, me,
Sit down.
Ms. McLean, or was Miss Haddad her client?
Courtroom 2.
Yeah.
Just put us in the breakout, right?
All right. So it'll be myself, Miss Julie, Deputy Chief Shelley Falk, courtroom 2, and Fulton ACDC into a breakout.
I got you, Miss Julie. I'm about to put you in there now.
Thank you.
Kasha. Kasha.
All right, I understand we had a bit of a lapse in our internet connection. Ms. Champion or Ms. Strong,
Yes, ma'am.
we able to get back online?
Yes, we're fine now. I'm recording again.
All right. Ms. Champion and Ms. Strong, I'll give you an update of the competency calendar once we're done with the regular cases, okay? Is the jail still with us? Okay, courtroom 2, do we have any other cases to address?
I don't believe so. I think we're
Alright.
done.
All right, is Miss Allen, okay. So let me just go over the calendars on the bench warrant matters. Position number 1 is reset indefinitely. It's going to be transferred to the division judge to address any possible bench warrants. And position number 2, I've set aside the bench warrant and the defendant will have to report in person. With regards to the probation calendar, and I do apologize, I did not have a printout, so I was really making notes all over the place. Ms. Champion, can you go over the probation calendar, please?
Position number 1, Mr. Brown was continue on probation. That's 1 and 2. Position number 3 is going to be reset till next week. I think it's the 3/28 calendar.
Yes.
That's 3 and 4. Position number 5 at 5 was revoked. Position number 6, the 6 and 7 will continue on probation. Position number 8 and 9, I think she was released.
Yes, she's not in custody. Janetta Ponder, yes.
And position 10 and 11, that's Twanetta Ponder.
Yeah,
Yes.
those were the mistaken.
Okay, yeah, those, okay.
So those have to be dismissed.
Okay.
10 and 11 are dismissed.
And position number 12 was continue on probation. 12 and 13 continue on probation.
Yes.
14 and 15 continue on probation.
All right. Ms. Vigiletti, could you submit a proposed order dismissing probation positions 10 and 11 regarding your client, Twinetta?
Sure.
What a name, Twinetta.
Yeah,
Because she twin to Janetta. Okay.
And when she told me, no, it was my twin sister, Janetta, I kind of thought maybe she was lying to me, but I looked it up and she was right.
Well, never doubt it. Okay. All right. Then we move on to our add-on calendar. And on the add-on calendar, position number 1, Dawson was a plea. Position 2 and 3 is reset to March 28th. Position 4, Brianna Marks was reset on a $5,000 signature bond through pretrial level 2. Position and further notice for trial. Position 5, McKinney is a plea. Position 6, Jalen Thompson. What are we doing with Jalen Thompson, Ms. Vigiletti?
I'm sorry, Judge. Mr. Thompson is pleading not guilty.
All right, please submit a waiver of arraignment. And this case is going to be further notice for trial.
Yes.
Then moving on to the main SAP calendar. Position 1, Albert is a waiver of arraignment and further notice for trial. Position 2 was a plea. Position 3, Brewster, 3 and 4 and 5 further notice for trial. Case was arraigned. Position 6, Bussell was a plea. 7 was null cross. Position 8, Reginald Colbert is a that's going to be Mr. Haddad's. and it seems that it's going to be a waiver of appearance and not guilty. Could Mr. Haddad please submit a waiver of arraignment?
I will remind him, yes.
Okay, and this case is further notice for trial. That's for Reginald Colbert. Position 9, John Davis was a plea. Position 10, Troy Evans, originally began as a plea, but he decided to plead not guilty. So this case is deemed, he was arraigned and further notice for trial. Position 11, Shonda Fields, I believe that was a plea.
Yes.
Position 12, Roderick Harris, what are we doing?
This is a case where the state has requested a DA transfer. Mr. Harris, I believe it's due to his prior convictions. I can double check.
Yes, Your Honor. It's actually due to his 2 prior family violence convictions, one which was a felony family violence conviction. I am still discussing this case with the DA's office.
All right, we're going to reset this to March 28th pending a transfer. Position 13, and that's Mr. Perry Hill. That was a plea. 14, Jimmy Hood. Okay, so shall I reset it to March 28th at 11 a.m.?
Okay.
That would be for the competency calendar. Yes.
Paul, I'm sorry, Mr. Bartles just left. I think the 28th would be okay. If we're resetting someone to competency, is March 28th okay?
Yeah, that's fine.
Okay, I'll send you the info. Okay, okay, yes.
Well, this is being reset for the social worker interview, so.
Oh, I'm sorry, I thought you said the competency.
No, Jimmy Hood is being reset for social work interview.
Okay,
So I can either reset it to competency or the 9 a.m.
okay,
I just don't know.
Yeah, I'm sorry, this is Mr. Haddad's case. I don't know anything about it. Let me look really quick and see how much additional jail time.
It's
was a time
no
served.
additional jail time.
Oh, I'm sorry that we didn't get to maybe do an interview today. Well, if the 28th is the soonest, then yeah, I think that makes sense then.
Okay, March 28th at 9 a.m. That's not competency, all right? If
Okay.
y'all consider him for the plea.
Okay,
Position 15, Christopher Horn is a waiver of arraignment and further notice for trial. 16, Jackson was a plea, and that was for 2 of his cases. 17, Lincoln was a plea. 18, Ogaris McGee is a waiver of arraignment and further notice for trial. 19, William McGee is reset to March 28th, 2024 for consideration of a plea, I guess, or an arraignment. Position 20, Murray Brantley was a plea. Position 21, Clifford Neal was reset to March 28th. And I thought it was a plea, but I'm not sure why we are resetting it to March 28th.
Let's see, Murray,
that was Neil, Clifford Neil,
Clifford Neal.
position 20.
yeah, he stated in the very final part of the colloquy with the court that it was not willing and voluntary, so we paused it a week to talk further.
Okay, all right. So that's why we're going to reset March 28th, see if he wants to consider a plea or whether he wants to have the case arraigned. 22 and 23, Twinetta Ponder, what were we doing with that?
She is pleading not guilty. She is set to be released because she had already bonded out on these cases.
All right. So this is going to be a waiver arraignment and further notice for trial, Ms. Vigiletti.
Yes.
24, Kenneth Scott was a plea. 25 was null pros. 26, Smith is arraigned and further notice for trial. 27 is reset to March 28th. That's Delano Swan. Both of his cases, that is. Position 28, Tony was a plea. 29, Tyson is a waiver arraignment and further notice for trial. 30, and 31 are waiver of arraignments and further notice for trauma.
And Mr. Tyson also had a bond modification?
Yes.
Okay.
I don't believe, yes, he did. He had a signature bond, which to pretrial, which he has to report after his parole hold.
Right.
Okay. Nothing like having the former director of ABLF come and vouch for you, so.
Marty, when he told me he knew Marty Ellen, I was like, oh, he's definitely decent here.
All right. Position 32, Cedric Williams is recommending a transfer. Is that a done deal for the transfer?
It is not, but on the plus side, we have the transfers for Tuesday in that are coming through from the DA's office. So by next week, we should have these transfers.
All right. So in this case, then I'm going to reset it to March 28th pending a transfer. 33, Gabriel Williams, and 34.
Yes, Miss Williams is currently unhoused. I'm working on helping her find some housing, and since the plea had, I think, requested a week of extra time, just requesting a reset to next week so we can work on that, so we have that resolved before she takes her plea.
All right. Cases are reset to March 28th.
Okay, thank you.
Are there any cases which I've not addressed?
Really quickly, with Swan, was it March 26th or March 28th? I wanted to make sure I had the right date.
I'm not resetting anything to March 26th, just.
Okay, so it was March 28th. Okay, I just put the wrong date. Thank
No,
you.
that's okay. I just don't want to load up the calendars, because we are taking on quite a few. All right, I think that concludes our calendar then, and we'll recess for 5 minutes before the initial appearance calendar. So thank you very much. You all are free to go with the exception of my host and Miss Champion. Thank you for listening.
Thank you.
Thank you.